Does anyone have any modifications to the agenda? Jan, do you think we should shut? Thanks, Todd. Sorry to interrupt. Any modifications to the agenda?
The last one was the one I just did yesterday, dated 4/9.
Mm-hmm.
And nothing since then.
Okay. And we do need to review and approve the minutes from the last meeting. Any questions or concerns? Does anyone have a motion?
2 sets of minutes,
Oh, two.
the January and then the special meeting in March.
So let's discuss the January 3rd, 2024 meeting. Would anyone like to make a motion?
I'd make a motion to approve the minutes.
Second?
I'll second.
All in favor say aye.
Aye.
Opposed, same sign. And so minutes are approved for January 3rd, 2024. And let's move on to March 25th, 2024. And do I have a motion?
Motion to approve minutes from March 25th.
Second?
Second.
All in favor say aye.
Aye.
Opposed, same sign. And minutes approved. We have a quorum here, so I think let's start and Sheena can join. Is that okay if Sheena joins us in the middle of the hearing? Okay. All right. Let's go ahead and begin. We have a hearing for Ashkan Alizadeh. Is that correct? All right.
My name is Ashkan Alizadeh. I'd like to thank the board for allowing me this opportunity for the hearing. I'd like to thank Ms. Murray also for being so kind with the communication, with everything. I definitely got lost this morning. So I've come here from Texas to show my commitment and my dedication for optometry here in Kansas. Now, the reason why I want to come to Kansas is because I have an aunt in Kansas City, and she does research. She's a full professor at the University of Kansas Medical Center, and she says it's the best place to start a life, start a family, and I couldn't agree more. So my mission here, the reason why I'm here is to ask for approval to be able to sit for the board, the Kansas State Board exam that's in July. Now, I feel strongly that I can pass this exam in July, and that'll show that I'm ready and committed to start for optometry in Kansas. Now, the board does have my full application. Ms. Murray does that. It includes my full degree of optometry from my optometry school. So regarding my board scores, as you know, there's 3 parts of the boards. Well, technically 4. There's part 1, 2, 3, and there's TMOD. Now, I have passed all the board scores. Regarding part 1, on my 6th attempt, I have passed all of the subtopics, besides for the biochemistry, which I did not pass by 1 point. But the previous attempt, I did pass that subtopic. I'd like to pass these out for everybody to see physical here. It's where I highlighted.
Thank you.
I blocked out all the other, it's pretty messy, so I blocked everything out besides the part 1 scores. On the bottom is the 6th attempt, where I did pass all of them besides the 69, which is the biochem section, which I did pass on the previous 5th attempt. Now, historically speaking, Kansas and North Carolina are known as an optometry school or some of the hardest states to get into because y'all do have the written portion and the practical that's also included. So I know your number 1 thing to be an optometrist is competency. You want to make sure I know what I'm doing, that I take care of the patients, I prescribe properly, and I do everything correctly. So I'm asking just for a chance to be able to sit for that exam in July, and this will prove that I am ready, because you do retest all of the optometry school and there's the practical portion. So this is why I'm asking to give me an opportunity, just 1 chance to take this exam. If I do pass it, great. If I do not pass it, then, I'll be done with the woods in Kansas. Don't worry,
So before we ask any questions, I'd like to make a motion to go into executive session to discuss some of the previous paperwork and to get counsel from Tim.
Since this is a hearing, wouldn't that be a closed session, Tim? Since this is a hearing, wouldn't she be calling it to go into a closed session?
Yeah, either's fine. I mean, interchangeable.
I'll second.
All in favor, say aye.
Aye.
So we will begin closed session at 10:12, and
You don't need to specify a time to reconvene. Yeah, as Jan indicated, it's just a closed session.
we proceed, Jan, can you just review the documents that were submitted for the record? Sorry to catch you off guard there. Mr. Alizadeh, did you have any other remarks you wanted to add?
No, the only thing else I can say from the bottom of my heart is just, please, I want to get my life started and just start paying loans off. And it's rough. I feel like I'm in a mental prison here and trying to get out. Just want to prove some people wrong that think I can't make it, honestly. It's pretty rough. That's about it. Thank you.
Do any board members have any questions?
I'll go. Have you applied for licensure in any other states?
No, sir.
Okay. So you've been working in the state of Texas for, since graduation?
Right now, it's been about a year and a half.
Okay.
I'm working with another optometrist at his clinic. I don't sign patients under my name, obviously, because I can't do that. So I just work with him and see patients with him there to keep the flow going.
Okay.
Essentially.
Have you appealed to the state board there in Texas, or why haven't you pursued licensure in Texas?
I'm just tired of being stagnant in Texas. I've always wanted to move out of Texas, to be honest, and that's the main reason.
Can you tell us about your attempts to, with the national board, have you applied to take the test a further time, or have you exhausted your resources?
I've contacted the national board, and in order to take it, again, there's a lengthy appeal process I would have to go through via my school. They gave me two options: either I'd appeal or I tried to contact the state board or wherever I'm going and show them. The reason why I called the board is to ask if they could substitute those two scores that you see to be all in one, and they said no, you can't do that. But what you can do is try to talk to the board, or you can try to appeal. And I believe if I take it a seventh time, all that time and resources all the extra time and resources is going to end up with the same outcome. To take it in a whole seven, I mean, it's 6 times, in my opinion, is ridiculous. It is what it is, but nobody should have to go through what I have to go through.
I have a question. So the first, I believe, 3 times you took it, your score was around 100. Had you prepared further, and that's what brought it up in the 200 range, or?
That's correct. The first few times, this was during COVID. I guess I was not well prepared, and I did study, take more practice courses, online courses, there's group courses, in order to continue just taking it again. So, as you can see, the scores did improve. So, I mean, technically, in my opinion, I feel like I should have better knowledge than other people since I've taken it so many times and studied the same material so many times, and I feel like that could give me an advantage in a way.
Any other questions or concerns?
I have a question for our legal counsel. Is there any ambiguity in terms of must pass all parts in order to sit for our exam?
No, I think it's pretty clear that's a threshold requirement to be able to qualify to sit for the exam. And so I think what the request is before the board today would be to waive that qualification for the applicant to be able to sit for the exam.
To waive the qualification in the statute?
The regulation, yeah.
Regulation.
Yeah, KAR 65-5-1 is the applicable reg.
Any other questions, concerns? If Jan's ready, she could mention our document submitted.
So we have, his application is complete. We have his application with references. We have transcripts from optometry school and all of his undergrad transcripts. We have his fingerprints. We have his waiver form. And I think that's, I was just going to look at my checklist and make sure I'm not leaving anything out. But as far as I know, everything is complete in his application.
Would anyone like to make a motion?
I would make a motion that we allow him to hold his application open, but at this time, based on the rules and regulations that we've applied previously, we not be able to exempt not passing Part 1 at this time.
I'll second. And I'll add that we'd love to have you practice in Kansas, but our hands are tied as far as the qualifications in the statute. This is not something that we feel we can waive.
Exceptions you could do.
All in favor, say aye.
Aye.
All opposed, same sign. Motion is passed.
Is there anything else I can do?
So, Mr. Alizadeh, I think that we are willing to hold your application for the one-year period. I feel comfortable that we'd likely waive the 1 year to maybe additional 90 days, and hopefully you can exhaust your resources through the National Board where they give you another chance to take the test.
If there's anything else, please send me an email or something. If there's anything else I could do. Okay.
All right.
Good luck to you.
We'll see you next year at the test. So Tim, you will prepare a final order to mail, or?
Yeah,
Kansas?
yes,
Okay.
we'll prepare an order that's sent to him and
Okay.
advises him of procedurally, what options may be under the Kansas Administrative Procedures Act.
All right, moving forward. Do we have Dr. Nolasco present?
She should be online.
Dr. Nolasco, can you hear me? I am going to move forward. Does anyone have any
Oh, she left.
questions about her application?
I'll see if I can't get her.
So Tim, I had a question for legal counsel. If Air Force Reserves is considered active military?
Yes, yeah, the military bill would include that with
It's back.
the definition of,
I think she's back on.
and under House Bill 2066.
Are you there, Dr. Nolasco?
Yes, I'm here. Hello.
Morning.
Good morning.
We are just reviewing your application. I had one question for you.
Okay.
This is Dawn Bircher, by the way. On your application, there is a question if you've ever changed your name by court order or otherwise, and you clicked no, yet all of your transcripts have a different last name on them.
That was an error then. Yeah, I mean, I got married, so.
And so do we just request new paperwork, Tim? Or does it matter?
I think you can just note it for the record as far as what her application says.
And then tell me, what brings you to the Kansas area?
Well, I actually live in Colorado, and I don't know if I'm gonna end up living in Kansas at some point, but I'm from Kansas, so all my family lives there, and I just want to get a Kansas license so the door stays open should I ever need it.
So just a question, doesn't it require kind of living in the state or, no, it doesn't? Okay. All right.
And then, Dr. Nolasco, any intention, you think that you would be working online?
Not currently.
Doing
I don't have
remote
any
exams?
intentions. No.
I'm sorry.
No.
Any other questions from board members at all?
What capacity are you working currently?
Well, a lot. I own 5 practices and I work a little bit in all of them. Today I'll be at 2 different offices. Friday I'll be at 2 different offices. Tomorrow I get to go to 1, which is great. And I'm a reservist in the Air Force, so I did that this last weekend too. I work a lot.
Would anyone like to make a motion?
Motion to approve?
Second.
All in favor, say aye.
Aye.
Aye. Opposed, same sign.
Nay.
And motion passes. Congratulations, Dr. Nolasco. You will receive further paperwork from our executive director.
Okay. Thank you so much.
Thanks. Tim, I don't know if you have a desire to really review if she would have fallen under HB 2066. I think she does.
She does, yes.
All right. Let's move on to the next applicant. Is Dr. Ziem available?
Ahead of schedule.
Since we have a few minutes, do you want to review that, Tim, the HB, or I can, 2066? I have the flow chart here in front of me.
Yeah.
I do have to look at it to refer to it.
Yeah, so there is within the board members only site, there's a flow chart, and I think there's a corresponding memo. Jan, is that right? Which sort of outlines House Bill 2066, which was passed by the legislature in 2021. It originated as a military bill to address our service members who may be stationed in Kansas, moved frequently, or military spouses for that matter, to attempt to open up pathways for licensure, that's a very big concern of the Kansas legislature right now, and so they've continued to address pathways for licensure. And so House Bill 2066, it's codified now at KSA 48-3406. So a threshold question always is who qualifies as an applicant under that statute. The statute includes someone who's a military service member, a military spouse, and then during the process of working the bill, it was broadened exceptionally to include anyone who has established residency in our state or who intends to establish residency in our state. And so when you have these applications, that's always going to be a threshold question of an applicant. Would they fall into any of those categories? You know, Janet's on our application now, whether they reside in Kansas or intend to reside in Kansas. If it's intend to, then you're always going to want to ask for, you know, what evidence are you presenting to be able to establish that present intention to relocate in our state. Right. Yeah. And she would, but she does obtain the, you know, the mechanism of that statute because she's a military service member. Right. Correct. Yeah. The definition of military service member is that broad. And it's, I can read it to you. It's a member of any branch of the U.S. Armed Services, U.S. Military Reserves, which would include her, or National Guard of any state, or a former member with an honorable discharge. Extremely broad, and there's no situs requirement there for where you're located. I mean, there's been a lot of discussion about how broad that bill is and sweeping it is, but I mean, that was, I think, the clear intention of the legislature to make it that broad. And so when a person does, you know, when they do fall under the protection, the bill kind of sets up two ways that you analyze the application, whether or not they qualify under your reciprocity statute. KSA 65-1505D is your reciprocity statute, which one of the requirements there is, I think, 3 years of consistent active practice, which has been a pitfall for some people. If a person say that a person doesn't qualify under that statute for that very reason, you then default to a non-qualified applicant under House Bill 2066, and it sets up a completely different methodology, which would preempt your licensing statute, your reciprocity statute. And it lays out criteria A through H. And one of the way that the 3-year active practice is modified is that if the applicant has worked for at least 1 year in the occupation, you know, for which the license is sought, then they qualify as an unqualified applicant under your act. And so that's a big way that I think it modifies our reciprocity statute. But the flow chart we have sort of lays out the criteria that you need to evaluate, but it is a different perspective in that situation when you know, someone would qualify for treatment under House Bill 2066. You know, if they don't qualify under your traditional reciprocity statute, you have to apply that analysis to determine whether or not you know, you still have to license them under House Bill 2066. One other thing I think I'll add there, you know, you do, if sort of limited circumstances, but you do have the ability to require someone to test if there's a determination that the law of their home state that they're using for reciprocity, it differs from Kansas law. And we've never done it to where we've done a substantive analysis of, you know, Oklahoma versus Kansas, for example. How we've typically treated that is that we can require them to take the jurisprudence exam, which is specific to Kansas law, which would be, you know, in my opinion, substantively different from Oklahoma law. So, you know, that option is available under some circumstances, but, you know, as far as, you know, the typical analysis of a reciprocity, this does alter it considerably. And so we always need to be focusing in on whether or not an applicant qualifies under this bill, and if so, then that's the analysis that ultimately you're going to have to apply if they don't qualify for traditional reciprocity. Said a lot. If there are any questions, we spent a lot of time on. House Bill 2066.
I did have Jan forward to you. Tim has made a very good flow chart for HB 2066, so hopefully Jan will get that forwarded to everyone. So,
And it's also on the board member only page at the very, very bottom.
okay, perfect.
Should be in the notebooks. So it should be everywhere you want to look for it.
All right, moving forward, Dr. Ziem, are you available?
Yes, I'm here if you can hear me and see me.
Yes, we're good. Tell us a little bit about your desire to get a Kansas license.
So, my husband and I moved to Cincinnati from Kansas City in 2020. My husband started his anesthesia residency at University of Cincinnati. And so we just had our baby daughter in November. So my husband graduates, so we're moving back home. And I have a practice I would like to work at in Kansas.
Can you share the name of that practice?
Mills Optometry.
And tell us a little bit about your current work. What kind of work are you doing?
So I just had my last day on Saturday because my daughter has had some plagiocephaly things. So now she has like 3 doctor's appointments a week, and we are moving at the beginning of June. So taking time off for the move and to take her to all of her appointments. But I've been working full time for my eye doctor in Milford, Ohio since June of 2020. I was averaging about 41 hours a week, doing just primary care, a little bit of everything.
Thank you. Any other questions?
I just want to clarify to make sure I'm looking at the right application. So this is Dr. Ziem.
Correct.
Okay. Okay, because on the question, do you reside in Kansas or intend to reside in Kansas, it says no.
So we just purchased a home on kind of adjacent to Briarcliff, between Briarcliff and Parkville. So we are living in Missouri.
Got it, thank you.
I would like to make a motion to accept the reciprocity application of Dr. Lauren Ziem. Do I have a second?
Second?
All in favor, say aye.
Aye.
And motion passes.
Thank you, guys.
Thank you. Congratulations.
Thank you. I'm okay to hop off of here, right?
Jan will contact you about your state test. Thanks.
Thank you.
Right. Moving right along.
Can I apologize. Since we started that discussion on 2066, can I ask also a question about that? Sure. So for non-military who intend to reside in Kansas, there's no like minimum evidence requirement for showing intention.
Usually Jan will request a lease or,
Okay, but is that like by law? Is that illegal? Like, is there a legal requirement? Is that our requirement? Like, what sets the basis for that?
Ultimately, it'd just be whether or not you determine, I mean, the board would be the finder of fact, and whether you determine that, they've established the
So we would
intention
be
to
able
your
to-
satisfaction.
Okay, I just wanted to make sure if that was one of those things that was outside of our determination, or we get to. Okay, thank you.
Yeah, so there's also, a mechanism where you can issue a
Probationary,
provisional,
or probationary,
probationary,
yeah,
and it's a 6-month period, right?
right.
And within that time period, if you find that the person has falsified something, for example, their intention to move to Kansas, they never had an intention to do it, and you can find out that they've lied to you, then you would have the ability to then revoke the probationary license on that basis. But I don't think we've ever pursued a probationary. Most of the time when they demonstrate an intention, it's pretty clear cut.
So, Tim, do you want to address the one that just passed this year with the military spouses, or do you want to do that at a later time?
Well, that's the waiver of fees. Yeah, so there's been a big push here recently. In January of '23, Congress passed it's within the Civil Service Relief Act, which basically sets up a different animal of, it's not even licensure, but if someone, under federal law now, if someone is relocated to, if they're stationed in Kansas, if their orders station them in Kansas, then, and I don't think we've ever had this kind of an application, but you know, the state boards are essentially required to, if they can establish some very simple threshold criteria, that they've been relocated in Kansas and they're in good standing in their home state, that you have to give recognition to their license. You don't actually give them a license if they don't apply for it, but you recognize their license from the other jurisdiction for the duration of their military orders. And as sort of a consideration for that, they have to submit to the jurisdiction of the Kansas board. And so that's a mechanism that's available to military members. And then what Jan's referencing that just passed, right, goes into effect probably July 1, is a waiver of fees for military spouses in our state. So if they relocate and they apply for licensure, renewal, whatever it may be, we went through that exercise of identifying all the different fees. But you know, our board cannot charge a fee to a military spouse pursuant to this new law. Correct.
So their annual fee is waived? I just assumed that meant their initial application. Yeah.
Yeah. Well, we'll circulate the bill to everybody so that you can see it. But yeah, it's. I mean, that's the way it reads.
Yeah, we'll be needing to update the reciprocity application again.
I mean, it probably doesn't impact you a whole lot as far as, but I mean, Jan, did you ever have concrete numbers on what kind of fiscal impact that may have?
I never did. They were just asked, you know, because I don't know how many that would apply. We don't ask that question, or never ask that question on applications, so.
That's a good point. You may know military, but not necessarily military spouses. Yeah.
Kansas, because that was a big other stickler point with the bill, is that they have to be in Kansas. Otherwise, they could be, Board of Technical Professionals brought up, it's like they could be elsewhere and never pay a fee. And never practice in Kansas.
Yeah, and I would expect this to continue. There's been a big push in the legislature to open up pathways to licensure, and I think every single session since House Bill 2066, they're building on it and building on it. So it's something to keep an eye on for the future.
All right, let's move forward with trade names. This is for Dr. Ryan Simmons and Dr. Morgan Schaller. Is this group online at all?
Dr. Simmons said he was seeing last patient like at 10:40, so he said he would join late, and I told him that we might skip over him and come back to him.
Sure. Tim, did you get the appropriate documents that you were wanting from this group?
Mm-hmm. Yes.
Okay. So their LLC business information has been updated and now is correct. Anyone have any concerns or questions for Dr. Simmons? Should we wait until he's available, or can we move forward? All right, would anyone like to make a motion?
I make a motion, we approve the trade name.
Second.
All in favor, say aye.
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 Opposed, same sign. All right, we approve the new trade name of Dr. Simmons and Schaller Optometrists. Let's keep on moving. So moving along to the report of the president. First of all, I'd like to welcome Seth Katz, our newest board member. He's already gotten his feet wet with 2 meetings now. So tell us a little bit about yourself.
Sure, Seth Katz. I'm born and raised in Kansas, hope to spend my whole life here. Grew up in Prairie Village and now live in Overland Park with my family. Went to KU for both undergrad and graduate school. I currently work at University Health, that used to be Truman Medical Centers. I've been there for about 17 years. I also teach, I'm also consulting faculty at the University of Kansas Medical Center. My wife's from Topeka, so I got to tell her I get to come back to our stomping grounds today. And yeah, I'm very excited to be a part of this. I was on the KC Tomorrow group last year, and one of the things was to get more civically engaged. And since I love my home state, wanted to do more, that's how I kind of wound up on this board. And yeah, I'm just looking forward to helping out how I can.
Excellent. I'm really glad you have a medical background. So, welcome. We do need to elect new board officers. Does Jan do this? Or do I do this?
Just so you know, it is in statute that at the April meeting, you are to elect new board officers. And most of the time, somebody makes a motion just to keep it the way it is. Sure. So.
Do we have to announce it officially? Like each position?
You can, yeah, the procedure's up to you, but I mean, you could do it individually or you could do a slate if you'd like. Or it's really up to the maker of a motion.
I think first I'll ask, does anyone have any expectations of changing? Any concerns? Maybe we'll just do a quick roundtable. Dawn Bircher, President.
Sheena Nagaraja, Vice President.
Gary Beaver, Secretary Treasurer.
Philip Walters, Member at Large.
Seth Katz, public member.
Would anyone like to make a motion?
I move that we continue in our present roles.
Second.
All in favor, say aye.
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 Aye. Motion passes.
Yeah, we do need to, there would need to be a motion to approve or accept the stipulation, but I mean, if you'd like, I can give just a very brief outline. Jan, did we anticipate Dr. Keeker? Okay.
All right, so we will begin to address the stipulation and final order for Dr. Arang Kukler. Tim, if you want to fill us in really quickly.
So Dr. Nagaraja was the investigative member in this matter, so she would recuse from any vote on it, but certainly if you have questions for her, that'd be appropriate. But pretty simplistically, Dr. Keeker had applied for approval of trade names for 3 locations. I'm sorry, 2 locations, Family Eye Care of St. Mary's and Family Eye Care of Seneca. And then it was determined that, unfortunately, he had used those trade names previous to the application, which you have a regulation KAR 65-9-1, which requires board approval before you use a trade name. And it includes a trade name or using a previously approved trade name at additional locations. And I misspoke, he had also applied for Family Eye Care of Manhattan, which we determined was a new trade name that he hadn't previously used. And so as part of the discussion with Dr. Keeker, determined how long he had used the trade names for. He did reach out to the board in November of 2015 in an email to Jan. He mentioned some of his locations, but he never went through the process of actually applying for the trade name, and the onus ultimately is on the licensee in that regard. And so there is a methodology that's used to determine the amount of a fine that's been applied, which I believe is $200 per year. And so as applied, Dr. Nagaraja did give him some credit for, some kind of an acknowledgement to the board back in 2015 in considering the fine. But what we proposed to him was and he accepted, and that's what's included in the stipulation, is a finding of the violation relating to, the regulation KR 65-9-1, using the trade name without board approval. He agreed to pay a $1,000 fine. In return, he was given conditional approval to use the trade names. In 2016, there was an order entered by the board relating to a Dr. Pingle, which essentially found that there would be public harm if the board would take away a trade name which had been used for years. And so that's part of the rationale that's built into this type of a stipulation. But that's essentially an overview of the stipulation if you have any questions. But I do think it's consistent with how the board has handled this, and so I'd ask that you all approve the stipulation today.
Dr. Nagaraja, tell me about the $1,000 fine. Was that based on years?
So that's per year per location. So that was, I think, 2 different locations and their years added together. So it was like so many, I don't have the specifics, so many for one, so many for the other. And like he said, Dr. Tim mentioned, because he did reach out specifically and ask, I want to make sure that these locations are up to date, and I think the board didn't respond, and it should have been on him to follow up, but also he did make an honest effort. So we did take that into consideration in determining how many years he was fined for.
Okay, thank you. Any other questions? Would anyone like to make a motion?
I'd make a motion, since it's been agreed to by both parties, that we accept the agreement.
Second.
All in favor, say aye.
Aye.
Opposed, same sign. And so the stipulation and final order passes for Dr. Kukler. So Jan, do I need to sign that today? Okay. I'm hoping that telemedicine didn't bypass your inboxes since we've been talking about updating regulations a lot. So telemedicine was on our agenda last meeting, and I could not make it. And so has everyone had a chance to review? So just to update everyone, because of COVID and changes in seeing patients and caring for our patients, this is not something, correct me if I'm wrong, Tim, that is being recommended as regulation as much as policy. Is that correct?
Yeah, it's guidance. It wouldn't be binding on a licensee, but this is basically the board, kind of laying out if you're going to practice this way, here's what you need to be aware of to, in an attempt to comply with optometry law.
So I believe what everyone has is the third edition of this guidance. Any questions or concerns? Does everyone have it? I can forward it if needed on the board website. Yeah. So Jan, I only have my own copy. I don't see it here on the. Oh, I found it here. I just want to make sure we're all looking at the same version. That's it. Okay. So I think our main question that we wanted to wrap up is the wording of the answering service options. And so I come from a different practice model. So I have 24-hour emergency service for my patients. And I don't know if that's normal. I don't know if what is available, but this very specifically says that you would be giving patients your personal information for 24-hour access. And I had concerns with that just as a female practitioner. But I also have services that, correlate with that. So any input on that, or?
So a question I have, I mean, because I'm in a small rural town, home phone number is published and out there. Does that meet the requirement of access? I have emergency rooms that call me on that and everything else.
I'll piggyback on that. It's 2024.
Mhm.
I'm on Facebook.
Mhm.
This is usually how patients get a hold of me after hours.
Mhm.
Does that meet the requirements?
Yeah, I mean,
Can't pretend like that doesn't exist, you know.
the guidance currently says that I think it's more affirmative than that, provide the patient the direct contact information. So you're accessible for urgent or emergent issues. Yeah, I mean,
I do that. I mean, I'm doing that already because middle of the night I'm doing stuff, but I can also understand why, especially female practitioners would not want to be showing up at a door at midnight to work on somebody that they're not sure who it is. And I mean, and that can be an issue for men as well, but how do we need to put rules and regs of our own that follow up after this, or how should we apply that appropriately for both sides?
I mean, it's probably, you're probably needing to focus on what's the industry standard. What would be sort of the minimum expectation here? I mean, to your point, making your information available, published, is that, and a patient can contact you through those means, is that sufficient? If it is, I mean, we definitely would need to revise the guidance to reflect that.
So my gut
That's
feeling
the expectation.
is there shouldn't be a difference between telemedicine and in-person. So if the guidance isn't there for in-person, I don't know why we would add it for telemedicine. And it is very, very rare that you have an eye emergency that needs to be tended to within like an 8-hour, 24-hour period. Most of those are caused by surgeons, and they need to be calling their surgeon.
One thing I'd like to point out, though, that not everybody may remember, your CanCare contracts that you have signed have this wording also. So,
I would have established that an office address and phone number is reasonable. You can contact me at my office if needed.
Agreed. Because our office then has further direction, like if there's an on-call number, or does saying seek care at an emergency room cover that? Does that count? Because that's what I know I honestly can't remember specifically in Kansas, but I know in other states for sure that that's reasonable.
So would that approach require a change to the existing guidance?
I mean, can we just remove it? If it's not already in regular statute for in-person?
It's not. It's not anywhere. I mean, if anything, it would be implicated relating to standard of care requirements and statute.
Or do we leave it and just say if you don't agree with it, then you don't provide telemedicine? That is the other option for doctors.
Yeah, I mean, the suggestion here is that you're going to provide your cell phone number, pager number, or some kind of personal answering. So, I mean, if that's not consistent with, what you think the approach should be, then that certainly could be removed. I'm not sure direct contact information. It could just be contact information or a means to get a hold of the doctor. I mean, that could be the approach that, and I think that's what I'm hearing, from your perspective, that would be the expectation.
Providing your cell phone number, pager number, or personal answering service number, it seems like an example rather than the statement. Provide the optometrist direct contact information so the optometrist examining the patient is accessible for urgent or emergent issues that arise outside normal business hours. This may be accomplished by. I don't think that example necessarily is all encompassing or is.
So how about we just eliminate that last? We just say, the optometrist examining the patient is accessible for urgent or emergent issues that arise outside normal business hours, period.
Well, the other catch is there's no real timeline with that.
Say again, I'm sorry.
I said there's no real timeline with this. You established care with somebody telemedicine-wise a year ago. This is open-ended to where you're still kind of on the leash.
And I think that's the same for inpatient care. Once you've assumed the care of the patient, then
Yeah.
so.
So I'm saying, to me, I mean, the quality or continuity of care and everything with this should be the same as live care, but this shouldn't be above and beyond live care.
I think what you proposed, Don, makes sense, just ability to contact whatever your wording was that you just said.
Just eliminating the wording after the semicolon?
Yep. So Jan, are you following? This is on Part E, Section I. Oh, no, Section little 2 I's.
Little two.
And we're just,
Little e, little two.
we're eliminating the statement, this may be accomplished by providing the optometrist's cell phone number, pager number, or personal answering service number. Which means I believe we get rid of the 3I, number 2.
So in other words, it's just going to be, it's accessible for, basically everything on for business hours on that thing is gone, right? On that second paragraph.
Yes.
Okay, so it's just going to be a period after business hours. Okay.
Or were you suggesting eliminating the entire number 2? I was
Well,
trying to clarify.
This was in little I, the 2 little I's. Yeah, it's kind of highlighted.
Tim's cringing over here.
So what if,
Exciting.
I mean, can you say something like, provide the patient, the optometrist, direct contact information consistent with live care?
I think that's reasonable. We're all looking at you,
Is
Tim.
that
That means answer.
Is that a settled?
Does that add anything, or is it just opening up?
No, I was deleting the rest. I was just substituting that in place.
Well, instead of live care, in-person care.
Yeah, okay, in-person care, yeah. Provide the patient, the optometrist, direct contact information consistent with
In-person.
in-person care provided to a patient.
Is that a known standard? Or could there be variances as far as what optometrists think?
I think there's definitely variances.
There's variances, but with all care, there's some gray area variance from one community to the next. You know,
I think
large
it's
for-
challenging because Dr. Beaver does very different care because of his location, seeing more trauma, seeing more emergencies than someone.
And single private practitioner practice.
Yeah. And and your community's going to influence your type of practice, absolutely.
Right.
So there will be some.
Do you think that's enough coverage, Tim, if we put, provide the patient with direct contact information consistent with in-person care?
Yeah.
I don't know if we can put in consistent with in-person care when we have no other guideline or policy for in-person care.
Yeah, I mean, ultimately, the baseline is going to be the standard of care. So I'm not sure what the set of facts look like where someone violates it. I mean, if you refuse to give someone your contact information, if that's even possible, then.
So when you're already engaging in teleoptometry with.
Yeah. I mean, right. I mean, if it's like a Zoom link and I'm not even sure what set of facts this could be, you discontinue your email address. But.
Who wrote this?
Hmm?
Who wrote this? Our board?
This is,
Guidance from our board.
It was adapted from the Minnesota board, I think is where it originally came from.
Because our big thing with telemedicine anyhow is it should live up to a standard of in-person care. So this is just a continuation of that.
I think the thought is to the possible induction of companies starting to come in and wanting to do telemedicine, and they are not a Kansas licensed doctor, or they want to do vision therapy, and making sure that they're still, again, doing everything that they're supposed to be doing.
So let's analyze that proposed language, with an eye to that type of abuse. So if we were to, change it to, so provide the patient the optometrist's direct contact information consistent with live care. So if someone's trying to provide care.
Consistent with inpatient care. You can still be live for video. So.
Okay.
I think we're at least all on the same page. So is this something we can approve today, or do we want Jan to provide us a final?
It's up to you. I mean, if you're comfortable with the draft as is. I mean, the one thing I guess I would say is that it's guidance, so this isn't enforceable. You couldn't say you failed to comply with section whatever, so we're going to, find a violation of the act. It's ultimately going to come down to standard of care. The one thing I would say you need to focus on here is that it could be used against you if you would find a standard of care violation, but they say, well, wait a second, your guidance says this, and we did this. I mean, that would be the perspective I think I would want you to look at it from. Make sure you're comfortable from that perspective.
I still think even under the standard of care aspect, from community situation to community situation, that's what's reasonable for someone in the same situation, which is what's going to fall upon this board.
What's the potential harm in leaving the guidance exactly as it is?
I'm going to immediately break it. I'm just kidding. Again, I think I'm an exception because I have, a 24-hour on-call service.
Okay.
So I'm just worried about doctors that do not provide or pay for that service. Again, is that on the doctor to just not do telemedicine?
But I think you're also open-ending it for the patient that, had the thing that they should have called you 5 days ago, and they've waited until the eye's about ready to fall out, and that instant that they called you or tried to communicate with you, they couldn't get a hold of you that instant. Well, it's in here. I should be able to get a hold of you at a moment's notice, 24/7. So you've opened up those doctors to litigation
I don't
because
know.
it's in here.
I can't imagine a scenario where somebody's unable to respond and they're subject to litigation.
I know of some dental offices that happened with.
Really?
Mm-hmm. After a 3-year litigation, it was settled, but yeah.
So I think the idea is, so for example, if someone is practicing telemedicine and we're trying to protect patients in those scenarios, and our main concern would be with people who might be practicing telemedicine who are not located here, correct? And so that's, I think, where this concern is coming from. So I think it's a minimal standard, but like you can't just provide, telemedicine during the day, and then if they call you because they have an urgent issue, you have to have some sort of guidance available to these patients. And maybe it's minimal, but there needs to be something. Like you can't just, have a way to contact them during the day because I want new contacts, but now I have a red eye after hours and your phone doesn't have an answering machine or a way to talk to someone or consult. And so, again, I think it might be very minimal where they need to at least say, hey, if you're having an emergency, you need to seek care somewhere, so that patients have some sort of guidance if they have a relationship with this company or individual. So,
Do we add a clause that says, so the doctor gives contact information, but also can guide patient to appropriate emergent care as needed?
and does it need to be doctor or can it be office? Because, we have, let's say, staff triaging.
Would you like to jump to the definition of practice and office in management?
No,
We
I
have about
decline.
60 pages of that. So I think that we should move ahead. So I think what I'd like to do is I will make a proposed change to this area, and then I'll send it out to everyone. And if we get a good agreement, then Jan will make a final, and then we can talk about that at the next meeting. Sound reasonable?
When did Minnesota first implement their policy?
During COVID.
Oh. When have we last touched base with them? I'm curious how this has worked out for them. Is that something we can do?
I think Gerard keeps up with them on a very consistent basis.
Okay.
Since he's now on the ARBO committee and the NBEO committee.
I'm just curious if they've run into things like because of that word.
Oh, gotcha. All right, I think we should take a break for about 10 minutes. So it is 11:25. So let's come back at 11:35.
That's okay.
How are you?
They understand it had nothing to do with me, it's just court. Court kind of simplified it, so it's okay. Well, it doesn't make sense. Because the reality is, the court told them what the violations were. They agreed with the one, and disagreed with the others, and that's fine. They know how it would go, it came back up to district court again, so there's no point having a hearing, you already know what the findings are. So I'll go over that a little bit in a minute, to see how they want to proceed. As far as this today, or that in general, I don't think it'll take very long at all. I think what you do, we give the option if the parties want to come back, and basically what you do is set it for an open meeting. We'll chat about it. Or you're not going to listen to it twice.
Killed a tree or two, huh?
See, does that have the transcript in it too? Lucky y'all. That's what I get to do all the time, so. So there's a forestry place down on the river, down near the water plant, that had a fire that started on Saturday, back in their mulch area where they shred and then sell mulch. And so they've been working on getting it all put out, but it's still been smoldering and smoking. And the problem is, like outside right now, it doesn't smell like this at all. But inside, it's getting into the air systems, and it's just recirculating it, and it's like, fortunately, our building, I notice it in the back entrance and in the foyer up front, but in our actual working space so far, it hasn't been, because I'm afraid I'll have people that are going to be like, I need to go. I felt bad for the guard downstairs, because it's horrible down there in the entryway where you first come in downstairs. Yeah, it's horrible down there. But yeah, it's just here to the kind of northwest of town, right along the river, and it just started on Saturday. It was a horrible, huge fire on Saturday. Not really sure how it started, although I have my speculations. I've not known wood to normally spontaneously combust. If so, I've been buying the wrong wood for when we go camping, because
A vacation, if you call it that. I didn't know if that was the official one. started doing neuro
It's a reading test. Yep. You'll understand why we gave this all to you here and how it's a lot better that we're doing it this way than the alternative once I get up there and give you a little briefing. Miss Bertram, Bertram's the only one that's here from, or Dr. Bertram's the only one that's here from before, right? We haven't had another one since. She's made a point of making sure that nothing goes to hearing after that.
and we will come back into session. I am going to hold on the report of the Vice President, and we're going to move straight to Judge Snell, who's here to present some information for us. Where do we start?
And I'd like to say that I'm glad to be back. You guys are nice folks, but, well, actually, it's the only one I actually know is Dr. Bertram. It's been a nice group, but I wish we didn't have to come back, at least under these particular circumstances. But it happens, and it's the way the process goes, and so we just abide by it. So I am Lauren Snell. I'm with the Office of Administrative Hearings, and what was it? Nearly 2.5 years ago, we had the pleasure of hosting the board for a hearing regarding Dr. Wade Abbey. I think he's a doctor as well, wasn't he? Yeah. For a hearing with regards to his proposed suspension of his license. We conducted the hearing, we issued the order based upon the decision that was made by the board that was there at that particular time, which included only one of you, which is why we're back today and kind of discussing it in this kind of formal/informal way as far as how to proceed with this. It got appealed to the district court. The district court, you have 3 notebooks. I think each one of you has 3 notebooks that have been provided to you that Jan has prepared at my suggestion. One of those documents in there, I would assume it's probably the last document in one of the books, is going to be a copy of the order from the district court. Or is it going to be the top one in one of them? Oh, okay. Somewhere in there. Oh, it's not in there at all? Okay, I need them to have a copy of this as well. And I give it to you because, so it's going to be this, actually, it's the Court of Appeals, I'm sorry, it's not even district court, it went up to the Court of Appeals. And the reason I want to give it to you is because it gives instructions on how this is to be handled from this point forward. You don't have it now, it will come. I actually have not seen the district court order now that I think about it. I don't think I ever received the one from the district court. I only saw the one from the Court of Appeals. There would have been a stage in between this board's hearing and decision and the order that was written and the Court of Appeals that that I have not actually seen. And I think the board were the ones who actually appealed it up to the Court of Appeals. And so long and the short of it is, the Court of Appeals went through everything, all the violations that were found by the board who was sitting at that particular point in time, agreed with one violation and disagreed with the rest of them, based upon the evidence. They felt there wasn't sufficient evidence to support. They don't do it, when they review these, they don't review them from a standpoint of hearing new evidence or anything like that. They simply look at the evidence that was presented to the board and then make a determination as to whether or not the board made a correct decision based upon the evidence that's been presented. They don't typically hear any new evidence whatsoever. It is strictly what was heard by Dr. Bircher and the rest of the board at that particular point in time. And so based upon that, they remanded it, which means they sent it back to the board for consideration, for further consideration once they made their determination. And they did it with some interesting instructions. They acknowledge the fact that this board has discretion as far as what kind of discipline they can impose upon a finding of violation. And weren't even saying that you could not impose a suspension as part of this. Now, I'm not saying, I don't take any of what I'm saying trying to point you down a certain path, because I'm not. This is purely, I am really, my role in this is just to serve and make sure that we follow the rules and then to write the order for you once it's all said and done. That's what I do. And so when the, when the court looked at it, they acknowledge, and it's on page 22 of the Court of Appeals decision that you will get. They go through what entities the board chooses to pursue is fully within its discretion. That was reference to the fact that there were other entities that could have been pursued that weren't, only Dr. Abbey was, and that it's within your statutory authority to determine what discipline should be imposed. They even looked at the fact that there had been prior discipline imposed against Dr. Abbey. They considered all of that. What they sent it back for is they just want, because, and this happens a lot, is they assume, based upon the fact that you had a group of violations that had been determined by the previous board, that that suspension was based upon the entirety of what had been concluded were violations, and that since some of those had been removed, that maybe that might change the board's position with regards to what discipline should be imposed. And so that's why they're sending it back. Now, your options are, and if anybody has questions about what it's like, it can obviously talk to Dr. Bircher afterwards, and she can give you, I'm sure, a lot of detail about how everything went and what it was like. Your options are you can have a new hearing. Not necessary. It wouldn't be for purposes of making findings as far as violations. It would be for purposes of being able to just hear the evidence because you've got a new board. I mean, the majority of this board is new. You weren't here to hear the evidence before. And so you could arguably say that's what we want to do, is we want to have a hearing so we can at least hear the evidence and hear it ourselves and hear the testimony from these people that testified before the previous board so that we're making a decision based upon what's presented to us. Or, in the alternative, the courts have recognized that if you have members of a board who were not present during the hearing, but need to be, need to participate in the decision-making process, that they can review a transcript or a record of what was heard by that previous board. Which is essentially the same thing that the district court did. It's the same thing the Court of Appeals has done. Quite frankly, it's kind of what I did when I was writing this order to begin with. I reviewed the record, because that's what, you know, I would love to say I can remember everything that's said during the course of these hearings. I don't, and I depend upon the record in order to do so. And so that is an option, and it's been recognized, especially in administrative hearings, that that is a viable option that can be done, and I've done it in other cases before, particularly civil service board cases where we had members missing and we had a split decision. We needed to have the members that were gone come back in and help with that decision. And so that's where we actually provided them with all the evidence. Here's everything that's part of this case. Review it, come back in, you're going to participate in deliberations, and you're going to help us make the decision. So that would be the other alternative to actually having a full-blown hearing again. And again, your hearing would be limited. I would have to create parameters for how that would go, because we would be looking specifically at the violation that was affirmed by the Court of Appeals. We would not be looking at all the ancillary stuff, because you technically shouldn't be taking that into consideration when you're doing this, because they weren't part of the affirmed violations. And so we would have some pretty strict limitations on what we would allow to be presented as part of that hearing process. Can make it a little bit difficult, not impossible, but makes it a little bit more difficult. Same thing's going to be the case if you read through it, because you're going to read through, and the testimony that you've been provided as part of the transcript is the entirety of the testimony, all the alleged violations. And so when you're going through it, you're going to have, that's why this is going to be important to have, because you need to know what violation the court affirmed and what ones weren't, so that you can be able to discern while you're reading through the record what you should be paying attention to and what isn't important and should not be considered as part of your deliberative processes. Yes, sir. As far as prior disciplinary actions, yes, because those were considered as part. So any prior disciplinary action will be able to be considered as long as it was considered as part of this process. And it was. I mean, there were things that were brought up as part of this process because he had been suspended before. He had suspended or revoked, I don't remember, but he got his license back. I know that. I think it was 2017 when he got his license back. And so you can look at all of that information as long as it was part of what was considered before. Now, if he's done something since then, you can't look at any of that. You can only look at what we would have had available to you on August the 4th, 2021. And so anything that would have happened up to that point is what can be considered. Anything, or actually I say, take it back. You can look at anything that would have been considered as part of the initial notice of intent to suspend that was issued. And so up to that point, because it's kind of that snapshot in time. And anything that occurred after that, they would have had to have done an amended notice to inform him of what else was being considered. Yeah, even the Court of Appeals acknowledged that it is undisputed the board imposed a more severe penalty because Dr. Abbey had been subject to discipline in the past, including revocation of his license for about 4 years. He argued the violation that resulted in the revocation of his license was totally different than those before the board currently. In addition, he points out the board found it appropriate to reinstate his license, yet there is some testimony before the board that could support a finding that there were similarities between the two offenses. But enhancing penalties based on prior conduct, even though dissimilar, does not require a conclusion that the action was unreasonable, arbitrary, or capricious. In attorney disciplinary cases, for example, prior sanctions are recognized aggravating factor, even though there could be some mitigation based on similarity or remoteness. And so they're final, so that you know exactly what it is they instructed. That said, we do find it necessary to remand this case to the board to examine the discipline imposed Because this court has found only one violation to be supported by the facts and the law, we express no opinion on the appropriate discipline, only that it should be reexamined given this court's ruling. That's really what it boils down to. That's what you're looking at. And in order for you to make an informed decision as to what discipline, that's why you have the homework, potentially, because you're going to have to know exactly what it was that he was accused of and what he was found to, what activities he was affirmed of having done that were in violation of statute and regulation that can be considered as part of the discipline.
The document that you're referencing, is that, we were emailed that, right? Okay, that's that same one. Okay, that's what you're.
Right. It's the memorandum of opinion that was issued by the Court of Appeals. And we can take down one more sapling and go ahead and get it out one other way. But if this is, I hear that you're not supposed to read a whole lot on your computer. I don't. I print out everything. I'm not good at reading on the computer. I'm sorry. I'm old school, and I prefer to have this in front of me. One, it allows me to mark it up a lot better, and two, I can adjust it as I need to for my eyesight issues. So anyway, so when Jan and I talked about this, communicated about this via email, I suggested that she at least go ahead and prepare that information for you. So what you have is you have a complete transcript of that hearing. So every word that was said during the course of that hearing, you have it. You also have all of the exhibits, if I recall correctly, of that hearing, so that you can, if there's something that's referenced in the transcript and you want to go back and look at it so that you can see exactly what it was, then you have it there to be able to look at and consider as part of it. And so my recommendation would be, based upon the fact that, and you can take this for what it's worth, it's merely my opinion, and my opinion is just that. I think it would behoove you to go ahead and just read the transcript, read the record, look at it. If you need additional information, if you feel like you need additional information, reach out to Jan. She can get with me, and we can figure out if it's appropriate to get it sent to you. What I would, based upon the directions that I'm given by this board, if that's what you choose to do, what I would do is issue an order or a notice of some sort of proceeding. I haven't even decided what to call it yet. I guess it'd probably be notice of hearing as part of your next meeting, or whatever meeting that you want to hold this as part of. That way the parties can attend. I would recommend that you give them a limited period of time within which to address the board, because you do have new members on the board. And so that way they can kind of come in and have their 15, 20 minutes of fame each to be able to tell you what it is that they want you to do, what their recommendation is that you do based upon what's happened in this case. And they will have instructions that it's going to be limited to the one violation that was made, or that was affirmed, and that we're not taking it, that you've already been provided everything to be able to review it. I mean, they would have all that information, basically what I'm telling you today. They would have that opportunity to make oral arguments, not present any additional evidence, because again, it's not subject to presenting additional evidence at this particular point in time. It's being reviewed for purposes of determining whether or not the discipline that was imposed was appropriate, not to determine whether or not there were additional violations or anything like that. And then you would go into deliberations to decide what discipline you want to impose. And of course, those are in closed session. Deliberations are always in closed session when you have a body like this. But you would do it as part of the meeting and then come back and announce what your decision was during the course of that meeting. And like I say, I know Dr. Bircher is familiar with that because we did it the last time. But that's what my recommendation would be as the hearing officer. But of course, you get the final say because it's your proceeding. I'm like I say, I'm just the one that kind of helps guide it along.
Can you give us a quick and dirty rundown of, is this public? Can this be discussed? Is it subject to coma, that sort of thing, for the new board member?
Okay. So The hearing itself, the meeting itself, or the hearing would be part of a meeting. These hearings are always open to the public, and of course, anytime you have a board that's going to be acting and you have more than 3 members of or more than a quorum present, a quorum or more present of the board, it has to be open to the public, and all actions taken have to be taken so that the board is accountable to the public. And so, and this is true of these proceedings as well. The only thing that would be different is, like I said, you can go into a closed session for purposes of doing deliberations. You are not required to discuss your thoughts while you're deliberating on how you should rule. I mean, when the group gets together and you're discussing it and saying, you know, this is what I think versus this is what I think, and no, I think you're wrong, yes, I think you're right, whatever, you know, however that ends up going, I've heard it all. That's not subject to being reviewed by the public. And in fact, the notes that I take aren't open to public dissemination either. But then you would have to come back and be an open meeting for purposes of announcing what your decision was coming out of those deliberations. Typically, it's you come together, you have that discussion, somebody decides this is the motion that we're going to make, you decide who's going to make the motion, then you come back out in open session. You have the motion, you have discussion, motion, second, discussion, vote. And that's the way it's handled. Now, here is one admonition that I'm going to give you. This is consider this to be as stern a warning as I can possibly give to you with regards to handling this case from this point forward. You have notebooks. There may be a desire by one or more of you to say, hey, I want to reach out. So Dr. Beaver, who says, you know, I want to reach out to Dr. Bircher. I want to find out what her opinion is on this. I need to talk to her about it. So he does that. Then he decides that he's going to talk to Tim about it. And then decides also I want to talk to Seth. That is an Open Meetings Act violation. Even though you're not all talking at the same time, what you're doing is you're going from one to the next, and you're having the same discussion with them, basically conferring information that possibly conferring information that you may have gotten from your discussions from each one of them to the last one, to the next one, however that may be. That can be construed as an Open Meetings Act violation. If you really have a question about it, talk to your counsel. You can talk to the AG's office. I know the Department of Admin also has people over there who do Cora stuff as well. I'm not an expert in it, but I've done it long enough that I know that that is a potential violation. Even if it's just, now, if you're out and about and it's just 2 of you talking and you discuss something that comes up with it, probably not a violation because you have enough members that 2 of you isn't going to make a quorum. But it's when you bring additional people in, either as part of a group setting or as part of a continuing conversation, that it becomes an issue. And so try to avoid skirting that. I would suggest you go and you read it individually, write down all your questions, highlight all the stuff that you want to highlight, and then I heard you mentioning June. One of you mentioned June is possible next. Oh, July. Okay. Then when you come back in July, then you bring up all your questions. You can either bring them up as part of the open meeting, or you can bring them if they're more of a deliberative in nature and you have a question about that, and I can answer that question for you. Sidebar. Then we talk about it in deliberations. Typically, if it's a question about the facts or about something that you need to get the answer from the parties, then it would be something you would do in the open meeting. If it's something that you just have an opinion on, you have a thought on, you have something that's, and you just want to bounce it off the rest of the members, you can do that in deliberations, but you all need to meet together in order to do that. It saves you a potential headache later. Me. And if Jan wants to be present, there have been situations in the past where we've had executive secretary or director present. No, you won't be able to have counsel present for the board. Was this a Brenda case? Who was the? Oh, it was you. That's right. That's right. It was Randy who was supposed to do it, and then you came in and did it, right? Okay. So I used you, you were a bad example, but got the point across, but bad example. Anyway, Tim would not be able to be present as part of the deliberations, nor would counsel for for Dr. Abby or Dr. Abby. It's just you. I sit in there so that I can take notes because I typically have to write your order to begin with, so it makes it a lot easier if I write those notes because we don't record it. We don't do anything with it. The only thing I do is I will write notes so that I can capture your thoughts, and then I write the decision. So I usually sit in there, and then it also allows me to kind of make sure that you're, again, following the process and considering the things that you should and shouldn't, and not considering the things that you shouldn't. Question? Have I said anything that you disagree with at this point, Tim?
So,
Yeah, and like I say, the one that's really difficult is a lot of people they get to this thing where they think, well, I mean, it's just me and Don talking, it's fine. And then you're like, well, wait a second, I'm not really sure that I agree with what Don said, so I'm gonna go have a talk with Seth. And is this a 5-member board? So then at that point, you've potentially hit, and it's not that you necessarily have, okay? It's still questionable whether or not you have, based upon what discussions were had and that, and the other. But if a member of the public were to get a hold of it, then what the member of the public is gonna do, they're gonna say, hey, I know these 3 talked. They may not have done it all at the same time, but they talked. And it's possible that they may have talked about this same subject matter. And so that was just a way to try to skirt COMA. And then you have to have a full-blown investigation as to whether or not there's a COMA violation, and it just becomes a headache for you. So the simpler way, in this day and age where everybody seems to think it's good to try to, well, you know, I'm going to go 4 miles per hour over the speed limit because they won't stop me until I get to 5. In this day and age where everybody thinks that's the mindset with everybody, it seems like in everything they do, don't do it. It's simpler not to, because then you don't have to worry about that becoming a headache for you down the road. If you don't talk, then you can simply say, no, I didn't talk. I talked to Don. I asked Don one question. This was the question I had, and I haven't talked to anybody else about it since. And that's simple. And they can go to Seth and say, did you talk to Seth? Did you talk to Gary about it? He's going to say, no, I didn't talk to him about it. And then it's done. It shouldn't be because, I mean, obviously, Dawn's kind of the center, and she's had that potential. It would depend on what Dawn was to do with it afterwards. But I would still suggest no. I mean, it doesn't make sense to even tempt it at this particular point in time. And as we're bringing this up, I'm getting into this probably a lot further than I should. I mean, we're not talking about the plans for a nuclear weapon or anything like that, where there's going to be a whole lot of interest in exactly what you may talk about afterwards. It's to avoid the appearance of impropriety. Because once you get to a point where you've crossed that line and it looks like you've done something that might be improper, then you cause doubt with everybody who may be listening in or who may be sitting in the audience, and they're going, well, if they were willing to do that with this, are they willing to do it with other stuff? And, and what's the whole point of having the meeting open to begin with if they're just going to go and talk behind everybody's back anyway? So that's the bigger issue here. I mean, the reality is, aside from this board, there's probably 1 or 2 other people that are truly interested in what happens with this case, and that's Dr. Appy and his attorney. This isn't something that's going to make the news. It didn't make the news the first time. And so a lot of people aren't going to really be that concerned with what happens with it. But it's just, if you start doing those things and you get yourself into, you start creating doubt. So that's why. So that's the bigger picture, but as for this, I don't think it's going to be a problem. But I hope that answers your. district decision? With regards to, well, this Court of Appeals has made it very clear that he does. And this particular action falls within, I mean, so. There's always the possibility. Ask Tim. Any attorney can make any argument that they want to on any given day. Sometimes it just depends on, what side of the bed they woke up on as to whether or not they're going to raise it. It can always be raised. But it seems to me, and again, I haven't seen Judge Christopher's decision, so I don't know exactly what happened in that particular one. But in this particular one, the Court of Appeals, who outranks Judge Christopher, in sum, we find that the evidence and law support the board's finding that Dr. Abbey engaged in the practice of optometry as an agent or employee of KPEG. KPEG was not licensed under the optometry law, and Dr. Abbey's practice was not ancillary to Dr. Parsons' medical practice under these facts. We find that there was insufficient evidence to support any other alleged statutory or regulatory violations found by the board. So that seems pretty clear to me that the Court of Appeals has come back and said, no matter what happened below, he falls within your jurisdiction based upon what he was doing. And so I think and they specifically sent it back for you to make a decision with regards to his license. So I don't think that's an issue. And I'm assuming this hasn't been appealed up to, if he hasn't appealed this up to the Supreme Court for a decision, because that essentially reverses, if I'm understanding, that would reverse what Judge Christopher said with regards to jurisdiction, and that would have been something that they would have needed to appeal up to the Supreme Court. In light of the fact that they have not, although I guess technically they probably have a little bit of time left. I think they have 30 days. So they have until next week. If they haven't filed by sometime around tax day with regards to that specific issue, then they're accepting the fact that he is subject to your review. So we'll watch for that and see what happens. We'll know more, and I guess just if you get something on that, let me know, because if that's going to happen, then this puts all this off for a while, because that'll be a bigger issue. If you don't have the jurisdiction to do anything with his license to begin with, then there's no point in us going back and doing a hearing. So as soon as either one of you hear anything with regards to that, let me know, or once the deadline's passed, if you want to let me know as well, that would be great. So I thought that was it. They don't allow any extra. See, I'm used to the world of administrative hearings where we allow all these silly extra days for stuff because it's supposedly being mailed, even though we don't mail hardly anything anymore. And so I couldn't remember. I haven't practiced in front of the Court of Appeals in forever. But so we should be good to go once Monday hits, if there's nothing gets filed. Other thoughts, questions, concerns? Anybody else? Anything you wanted me to talk about besides that? Okay. Well, then you have everything, and I'll just.
So today, do we need to officially decide if we're holding a hearing or just reviewing? Do we need to do that officially, or?
It would be nice to know for sure what you intend to do. Like I said, I think you need to at least schedule something and make it part of your agenda for your next meeting. It's just a matter of whether you want to do it as a full evidentiary hearing, or do you want to just do it as a simple remand, review the record, and issue, with allowing opportunity for the parties to at least make their say and then make their decision based upon that order of remand. If there's no more questions, I'm going to sit. And I'm here if you have other questions. I won't go anywhere right away.
So I think just to bring everyone up to speed, realize if you're in the actual live hearing, you also know nothing walking in. So it's not like you, I think you may feel like you're walking in clueless and you don't know what's happening. That is what happens the day of the hearing as well, besides the investigative member, so. You want my opinion or my, I would really like to avoid going into a hearing just because of I think there's paperwork, I think it delays just the process in general, but if anyone feels strongly about having this in a formal setting versus reviewing the transcripts. I think when you review, there will be some questions that kind of come up, but I feel like overall it's pretty straightforward. I don't know, can they ask me questions on why we made decisions during deliberation? For example, we went into court with, X, Y, and Z, and we knocked off a couple and only pursued more.
I don't know why they couldn't. But ultimately, I mean, I'll sit in the role as advocate, so you need to address those types of issues the judge know. Yeah.
Jan, what do you think about the July meeting? Do you think we're too packed with interviews and test taking? Should we schedule something?
First of all, as far as time, I would say, again, make if you're going to do that way, make a set determination as to how long you're going to offer the parties to be able to speak. So you can actually, aside from your deliberations and how long that might take, you can really kind of set this for your, if you want to say it's going to be an hour, we're going to give each of you 20 minutes and we're going to take 20 minutes to deliberate, then that's what you can, you can kind of craft a space for yourself with regards to that, and that's not unheard of. Second of all, as relates to the other thing with regards to asking questions, you can certainly ask those questions. I think what you need to be careful of is that you really can't take into consideration any of those other violations that were found but overturned. Those can't come into your process of thinking. When you're making your decision as to what's the appropriate discipline to be issued in this particular case, should it be suspension? Should it be something less than suspension? Should it be nothing at all? You have to do that based upon the violation that has been affirmed, and that only. And so while you can certainly ask those questions, the reality is it's probably not, it should not play much, if any, of a role. And I can tell you from my standpoint, I'm going to do my best to keep any of that information out of any final order that gets issued, because that's going to be asking for an appeal immediately. I mean, as soon as you say anything about those where the Court of Appeals has said those weren't violations, then you've set yourself up for having all this all over again. So that was what I was going to say with regards to it, because, yeah, Tim can't really say a whole lot about that since he's going to be presenting the case on behalf of the board, which has always been weird to me. He presents the case on behalf of the board to the board. But anyway, so just, I guess as you're going through that, keep it in mind. You can discuss anything in deliberations. That's the beauty of having it closed. Nobody knows what was said. But when it comes to making your final determination, make your final determination based upon the violation that was affirmed and the evidence surrounding that particular violation. That's why you have everything. I mean, I could have gone through and pulled out a bunch of stuff that didn't have anything to do with it. But I don't want to be the one that's accused of going in and somehow, well, it's not even that, of somehow leaving something out that shouldn't have been left out and creating some, it's all there. You know what the Court of Appeals has said, or you will know once you read that decision, and what they said was appropriate to review and what's not. And so as long as you follow that and let that guide your deliberations, you'll be just fine.
Okay, I have two questions. For, you said we could set a time limit on the parties. And so do we set that per party? And also, how many do we expect? As it's public hearing, can other people talk, or is it just going to be Dr. Abby?
So,
or
There's only going to be two that would be allowed to present. It's going to be counsel for the board would be able to present on behalf of the board, and then counsel for Dr. Abbey is going to present on behalf of Dr. Abbey. And you, like I say, you have the discretion. That's the beauty of CAPA. It really does, it gives you the discretion to control how those hearings are conducted. And so as long as you give them an opportunity to be heard, that's the main thing. They may choose, Tim may say, you know what, I don't want to say anything. I don't have anything necessary to say because you've got the record before you. But the other side may decide that they want to make sure that they have an opportunity to say something to you just to, and so basically it's going to be like a closing argument. You've reviewed everything and they're going to give a closing argument to you. And so, yes, you can limit all of that keep it reasonable. You don't want to be too restrictive to the point where they feel like they aren't getting a chance to say, but if at the same time, as long as they've been made aware of it up front, and you can say, you know what, this is the time you were given, we've reviewed everything, you narrow it down to what you really feel is important to say, then they should be fine. And I'm going to cite to the case that allows for this process as part of that notice as well, just so you know.
And then with Tim's role being different, like since he won't be in for the closed session, can we still ask him for reference on like when we're trying to discuss the final order, or we have to determine, okay.
I'll be your legal reference at that point. I'll be the one that will help you out from a legal standpoint. I will try to bring in all of the regulation and statutory references that we will need as part of that. If I don't have them with me, then I'll try to have my computer so we can pull them up easy enough so that we have everything. That's what we did the last time, is because there were a lot of questions about the various regs that were raised during the last deliberations. And so we went through each one of those in a lot of detail during those deliberations. And so I'll have all that because, yeah, Tim won't be allowed to be in there at all. Because then he'd have the ability to somehow influence what you're deciding, and as counsel, he can't do that. And I won't be there to influence your decision, by the way. I want to make this very clear up front because a lot of people have been misinformed in this. I'm not there to tell you how to vote. I'm there to make sure that you're paying attention to the rules and the processes as you go along to make that decision. That's all I'm going to be there for. If something comes up, if there's a question about whether or not something happened and I recall, I'll bring that up. But as far as making the decision, I usually like to sit back and just take it all in and allow you to make that final decision. So.
All right.
So the July meeting right now is blank. Usually, the way the day the exam works is that I usually give the law and the practical upstairs in the Senate chamber, or the written in the Senate chambers, and you guys are having the board meeting, usually starts about 8:30. While that's going, while they're up there doing that, then you're having your board meeting. And right now, the only thing that I might have on the agenda is the regulation hearings for the two that just got approved through the AG's office. And right now, other than that, it's blank, and I can keep it, I usually try to keep it fairly light. And usually then in the afternoon is when you have the interviews with the candidates, starting like at 1. So if we need to, we could push that back some too, depending on how many candidates we actually have.
I think let's plan on July. This is quite a load to get through, even before then. So I think that's a good plan. Any other questions, concerns?
Yeah, if you come up with an exact time, let me know. That way I'll get a notice out. You can figure all that out, get it to Jan. And
Okay.
I'll get a notice out to the parties so that they know exactly what's happening. And say, since there's it should be fairly easy. Hopefully Dr. Abbey and his counsel will be available. That would be the only potential pitfall that we'll have. And I assume that you're going to be available already, so I'll reach out to, I think Diane's still representing him, isn't she? So I'll reach out to Diane Belquist, who's the attorney for Dr. Abbey, and just make sure she's available. I'll have my legal assistant do that this afternoon. And just tell her to plan sometime during that day, we're gonna have this, and then we'll go from there. But don't worry, I won't talk to her myself, I'll have my legal assistant do it. Since we're on the public record here, I'll make sure it's understood, I'm not talking to the purpose of counsel. All right, any other questions for me then?
Thank you so much for coming.
Absolutely, good, happy reading. Thanks, Dan. Let me know.
All right. Do we have a report from the Vice President?
No report at this time.
And any report from the Secretary Treasurer?
Was curious about the board's particular view on radio frequency treatment with that device.
Brian McCarthy is an OD or
Yes.
sales rep or?
OD. Because we've already approved and it's in use, the IPL unit for treatment of my Boehmian gland disease. And this is a component that's available on that same unit.
And what is the use of it again?
Treating my Boehmian gland dysfunction.
Does that same technology fall within lumps and bump removal?
It does not, because you're not removing. For some radio frequency devices are for lumps and bump removal. This is not removing tissue at this point, so that's why he's asking for a clarification from the board.
That seems really tricky to me.
I'm not disagreeing, that's just,
Oh, sure.
that's the topic at hand.
Sure. So I can update Seth within the last maybe 90 days, Todd. There was legislation to expand the scope of optometry, which did not go through legislation. And so this is kind of on that bubble of, you know, where does this lie among our scope? So I'm a very black and white person, so kind of all or nothing. So if we allow radio frequency, can we add stipulations? We just have to, in this day and age, our wording has to be so specific.
Well, but on the all or nothing front, and I'm not taking a position yet, I mean, light treatment with different things, I mean, you know, light treatment versus laser treatment, I mean, you're still within light wavelengths. So you got to look at it as, and I think it needs some more research probably on our part, but I think you have to look at it as what's the mechanism and what actually are you treating versus removal or this and that. So I think it warrants enough investigation on our parts that it may not be an all or nothing situation. But I don't have enough at hand to tell you that. This is just something that came to our attention recently, and I think we ought to review between now and the next meeting. Yeah, yeah.
So Dr. Beaver, how do you feel about gathering more information about this technology, kind of determining the availability to optometrists, liability issues, and
I'd be glad to
Kind of finding a
research
window.
that and bring position information to the board
Okay.
for their review.
And so we will discuss that again at your next report.
Okay.
Until we have more information. Any additional comments from your report? Dr. Beaver?
No, no
Dr. Settle?
additional,
Okay.
pardon me.
And Dr. Walters? Seth, any news to report?
No.
Thank you. Tim, the floor is yours.
Yeah, I have nothing additional. I think the only thing would be, as Jan mentioned, we can update you on anything that happened during the legislative session. But as far as what I know, that would be the bill we referenced about waiver of fees for military spouses.
All right, Jan, if you want to dive in.
Yeah, and I would say that it also includes fingerprints, and currently fingerprints, they pay, the individual pays for the prints, and that money goes straight to KBI. The board doesn't see any of it, and so when they said everything, that includes that, and so we would be paying KBI for fingerprints, which would be an additional expense that we don't have currently.
So if the legislature is the one waiving the fees, wouldn't KBI be subject to waiving the fees?
Don't know. I got an email from KBI that's wanting to know approximately how many we would have, which I really don't know. You know, it'd probably just be a handful, but who knows?
My guess would be no. They'd probably want you to bear it, or each, you know.
They might want it, but I'm just saying,
Yeah.
they're under the same umbrella.
Yeah. Well, I mean, it's something to take into account, I guess, at budget time, if you do notice some kind of impact that it's a legislative created vehicle.
So Jan, do you want to continue with our website update?
The new website is sort of up and running. I got the link to it that I'm now testing, doing all the fun stuff with. It's going to show it to you real quick. I have training starting on Friday on how to program it and do all that fun stuff. But it looks kind of cool. I can get on. Hey, why isn't it letting me on? No, I was trying to log on to WebEx so I could show it to you. I just saw join browser. Yeah. If you know what you're doing. I don't have a clue. That gets me going. I'm impatient some days. So this is the new website that I've been testing it. You go public information, it takes you here. Down, you got little bubbles. Yeah. Well, and these, what I call the bubbles, we can program whatever we want to, the top, the public information, those I think we can change a little bit too as to what goes where. But I noticed the bubbles don't really work yet. You know, optometrist. Pretty much what we have now, but I'm still testing. I just got this last week, so. But that's the new website. Oh, looking to launch it like June 5th after renewals, because I figured if I launched that before renewals was over, I'd get a bunch more phone calls and people wanting to know they can't find anything on it, so. That's the pretty board new. And it is also supposed to work on mobile devices in all of the different browsers. So I haven't tested it on my cell phone yet. So on the ARBO, or on the board member only thing is the ARBO report that I send into ARBO every year. So if you would have anything issued or see it, review it, if you have anything with it, let me know. It's not due until May. But ARBO usually collects reports from all the states, and then they combine them into one big, huge, it used to be a notebook, but they don't do notebooks anymore.
I was kind of surprised on there. I mean, the questions they're asking are pretty in-depth. Is that something you've been used to, it always being like that?
Yeah.
I mean, it kind of makes it sound like they're the managing entity over all the boards, and it just seems like that's a little bit of an overreach, but maybe that's just my perception.
I don't know. How would you respond to that, Jan?
Well, they're mainly, it's kind of like pooling the boards, and if one state's got an issue, then could be another state's got the same issue, and then they, and that's the whole point of going to the ARBO meetings, is that you find out what other states are doing and how they have fixed issues.
I think ASCO uses it quite a bit as well. Just, these states are glaucoma certified. These states have laser certification, and it's just a quick and easy way to get that information without, tracking everyone
I mean, I
down.
can see that part. It just seems to me like they wanted in-depth things of actions we've taken on or against somebody, and it just
I mean,
felt
that's,
overreaching, but that's just probably me.
yeah.
I think too, they're very aware of, potential super boards coming into play and, demonstrating our activity and what, how we're staying involved.
Okay.
So, and then next up is the ARBO conference. I just need to know who wants to go so I can pay registration fees. Usually how this works is I pay the registration fees and you are responsible for making your own travel plans, making your room reservations. I need to make sure you know that you're supposed to make your own room reservation, because one year I had a board member that did not. And like the week before, he's like, oh, you didn't do, so, yeah, flight, everything. The board will reimburse you for all of your expenses. And like I said, I just need to know so I can start, get registered and. You going? Anybody else going? You're going? And if you would like, I can give you the board's credit card that you can reserve your room under. But if you do that, just let me know, because I got to make sure with it being close to year end, I need to make sure I've got a PO for it for the right amount. And unless anybody objects, I will be going also, so. And can I take a break for 5 to call?
Are we officially in meeting still? Are we taking a break, or is just Jan taking a break? I didn't hear, so I didn't know. I was like, are we?
So we will take a break this is 12:35 until 12:40.
The next step I had was the exam. Usually you guys get together prior to the exam. We have a meeting to pick out what questions we want to ask patients, that stuff. I have confirmed with Dr. Atterbury that we can use his office again this year. So I didn't know if you want to schedule the exam meeting, the pre-meeting.
Oh, gotcha.
Yeah, so, otherwise I can use just last year's exams, the law, the written, those type, and then you can figure out patients later.
Got you. I know there was a discrepancy last year on whether we will be providing patients or if Dr. Atterbury will be providing patients. Or perhaps he's providing a list and you will be contacting them versus his staff contacting them?
Usually somebody contacts them, I just get the names so I can do the payments.
I think, so I think we should check with him to
Yeah.
measure his involvement.
Okay.
Just determine if we need to be able to provide more patients and/or, I think his challenge was the amount of time he was investing in coordinating things, and he really has nothing to do with the test, so.
So I will get with him, I'll see you on the emails, so
Okay.
you know what's up to.
So last year, we divvied up most of the board testing to, I would be in charge of writing the clinical exam, going through the charts, pulling charts. Vice President does the written exam. There's an entire bank of probably 450 questions. Some are very good questions, some are no longer relevant, some are just bad questions. So Sheena, I think we would just expect to hear from you if you would like each member to submit questions, or if you feel like your bank of questions is adequate right now.
I think it would be nice to continue to have new questions submitted. Something I noticed while going through it last time was there was several repeats and things like that. And just to keep things fresh, I think it'd be good if, I think last year we had everyone submit like 5 questions. And
Okay, is there date-wise, we probably should do that fairly quickly.
That's what I was going to ask.
Yes,
Yes.
yes, there's a tab across the top on the board, one of them says exam. I think,
It's there.
yeah, and that's all of the questions that from at least probably 2012. That's why there's.
So logistically, it does take some time to compile the test, and Jan has to put the test together. So Sheena, maybe you can let us know within the week a final date that you'd like the question submitted.
okay.
To remind.
We got to give you the answer to, or you want to get?
Yes, please.
And then this meeting, we usually do this over Zoom, is that right?
Yeah, Teams,
Okay.
yeah. And the law exam's one that we've been using for the last 10 years.
And you don't want pictures included?
You can. There are some questions that do have a picture or graph or something when you actually look at it.
Yeah, I see where you got them here. Master question.
Yep.
Updated 2023.
Yep. Because I know some of them, because I remember the giant eyeball one.
The exam questions or the interview questions?
The exam questions. The interview questions, I email them out to the applicant so they kind of have an idea of what you might ask type thing. You don't have to stick to whatever.
Well, I'm not a doctor, so I would be like,
Well-
I can Google it, and yeah. That's why I was asking.
Sorry, yeah, you don't have to.
Okay.
Yeah, sorry.
I don't know the answer to any of these questions. Well, except it gives me the answer here, but.
You might make it interesting.
So Jan, do you think the last 2 weeks of May is too late?
No, because I probably won't get around to printing them until like the 1st of July.
I'm just worried with those last 2 weeks, with the ARBO meeting and everything.
Yeah, but ARBO's in the middle of June.
You ought to say mid-May, just so for dragging our feet.
I can do that.
The patient ones are the ones that usually I get at the very end.
And then what's easiest? Do you want to send out a poll? Or do you just want us to move forward and set a date right now?
I can send out a poll, if that'll work.
Okay. Maybe we'll look at the week of May 13th.
And this is for to review just test details before.
Yes.
So how many questions do we do anymore? I mean, total is that for the test? 100?
Usually.
I think it was 100, right?
50, something like that.
We usually do like 52. So in case we end up throwing out a question or, yeah, so.
Because back in my days, it was 3 days of written test.
Just because Jan doesn't want to grade them.
Yeah, it becomes all about me and what makes my life easy this time of year. Okay, moving on. Renewals. Renewals seem to be going fairly smooth. I've only had one hiccup with the payment, and that was somebody that used their AOA credit card. AOA has somehow blacklisted our site. And so this person had to actually call AOA and get it whitelisted. And I've had somebody else had the same issue, and they just used a different credit card. So, but so far, knock on wood, it's been fairly smooth for once. And I do have a meeting set up next week to start talking about the new database. That'll be hopefully in place by next year. And we already did the scheduled the Wade Abbey hearing, because I have that next up. You want to start it like at 9 o'clock on the?
Yeah, I think that's reasonable.
Okay, yeah, and still start the meeting at 8:30.
Yes.
That's what we've always done years past. It's always been, I start the exam at 8 and the meeting starts at 8:30.
Yep, that's good.
And then finally, the regulation hearings, we have two. We have KAR 65-5-15, which is the CE reg that needs to have a hearing. And then we have KAR 65-15 is the active practice one, sorry. And then KAR 65-5-6 is the CE reg. And I'm assuming that we want to do these on the same day as the exam or the next board meeting.
Yes, and the hearing is, meaning it's made it through the final process?
Yeah, the hearing is the very last step. You have the hearing, you pass it, and then it has to get published in the Kansas Register. And then 10 days after that, then it becomes official.
This is like,
Yeah.
congratulations, a big deal.
Yeah, and we have to have it published in the Kansas Register, the hearing date published in the Kansas Register 60 days prior to the hearing.
Okay.
So if we do May, or do it in July, I've got plenty of time and not push into,
Yep, I think that July is good.
okay. You want to do it first in the meeting, like at 8:30 when the meeting starts?
Yes.
Okay. And that is all I have.
You forgot the announcement that you're delaying your retirement.
Oh, no.
Go.
I keep working on that.
My new acronym, have I told you my new acronym this year is STIR? Screw this, I'm retiring. But no, and it's something we're supposed to start working on the new database in August. And so I'm hoping that it will be up and running by March of 2025. The Real Estate Commission, who's been working with this company for, I think, 2 years now, they're supposed to be going live the middle of June. So, but they were working all the bugs out with them. So hopefully ours will be smooth but no. Still not.
Let's see how it goes.
I wanted to just add for the new members for the July meeting, we have the option to drive down the night before. They get a hotel room for us. I don't know if you said that.
I can't remember. Yeah, I will. And I will check out the hotel this year. Last year we had an issue with the hotel and remodeling and water leak and no elevator, and that we ended up switching hotels at the very last minute.
Very exciting.
But
And then did Did we set an actual date for the May meeting, or are you just going to send out a poll?
I was going to send
We'll send out a poll for that,
Okay.
yeah, week.
Yeah.
And the hotel is not back in shape yet, because I came to Topeka a few weekends ago, and
I was going to actually physically go and look. If not, I'll put us up, and if you don't want to take that risk, I'll just put us up all in the Holiday Inn. But
it was a really nice place to stay, so if it's, I'm sorry? No, we're not that fancy. This was the Hyatt.
place.
But I mean, there were no elevators, there was 3 inches of water on the floor. It was, and they checked us in.
They ran out of soap.
Wow.
Yeah, it was a mess trying to get the board's credit card on.
Yeah, interesting.
But
Yeah, but I'll be
usually,
coming up there.
I put everybody up the night before, so nobody has to get up and drive early unless you really want to. And then Friday night, we stay over Friday night, and then Saturday is the exam, depending on how many applicants we have is what time we start. Normally, we'd start at 8, and we're usually done by noon, or the applicants are done by noon, and then it's you guys deliberating as to who passes, who doesn't type thing. But that's the Saturday thing.
All right, any comments from the public?
Good morning. A couple things, actually. So just update you on our legislative stuff. As mentioned earlier, our bill did not pass this year regarding scope, but that'll be back. We'll be continuing to work on that. The other issue that just be aware of with the driver's license, I kind of update you on that every time. We're still having some issues with the driver's license forms. One of the most recent ones we're hearing is actually on the online renewal forms. Those doctors that are choosing to do online renewals, some of them are not able to open the emails anymore from the state. So I have somebody with the state looking into it because they're not able to verify even if they wanted to. So they're concerned that patients are getting licenses without knowing whether they actually meet the qualifications or not. So we've let the state know about that, but in case you hear anything on your end, just wanted you to be aware of that. The other thing, just as an FYI, so through one of our roles is that we also operate the Impaired Provider Program. And that is to make sure that if there's a provider that has any mental health or any other substance abuse issues, that they are able to get treatment. We actually are having a presentation about that at our upcoming meeting for para-optometric staff, so that they can be aware of some of the symptoms and warning signs, so that if they need to report, then they can do that. So that's part of our thing that we contract with the state board to do, but I just wanted to make you all aware of that. So, any questions or anything for me? So, it is interesting because if you talk to them, theoretically, Kansas optometrists should have a few optometrists that are part of that statistically, and we haven't had a lot that have had any impairment that have been reported through that. So we just want to make sure people are aware about it and know that if there is a substance abuse issue or a mental health issue, that there is a resource for them to go through. It's confidential, it's handled, so that hopefully it's an issue it's taken care of before an issue affects patients or their licensure. So, anything else?
In June of 2023, the DEA has changed their regulations for license. Will the KOA at some point be offering classes or work with the DEA to set up optometry?
So that's a very good question, and actually the AOA is working on that. They were not included in that process initially, so they have made available a course that's through a different entity, which to my understanding is not COPE approved. And it's something that it's not through the AOA or the KOA, so that would be something that if the board wanted to approve that, it would be something separate that you'd have to look at. But the AOA is looking at that to see if they can develop a course and get it approved by the DEA in order to be able to do that.
Okay.
We're working on that. Because that is a question that's actually come up, just to get some clarification on. We've had doctors ask us if that course does count toward their continuing education requirements. My reaction was that it probably didn't, because it wasn't an approved provider of continuing education. It would meet the DEA requirements, but I'm not the board. I told them to call Jan, so I don't know. Okay, so.
Well, and I think as long as someone brings it to us so that we can review it
It's it's a psychiatry association or something that's put these on, and it's online modules. So that's why I said you need to talk to the state board, because my opinion, based on, it doesn't meet the requirements of it being automatically approved. So it would be something that they'd probably need to have the state board look at.
Gotcha. I just assume we wouldn't automatically do it. Someone would have to request us to review the courses.
So anyway, there's that. So, yeah.
Okay,
Okay.
thanks.
Thank you.
All right. Do you want to do a full hour or like 45 minutes? Yeah. All right. So let's go ahead and break. It is 12:55, and we'll break for 45 minutes.
Sure. So we bring it up here? Yep, okay, good.
Zoom the meeting. So Jan, are you going to pull up our regs for us? And so, Tim, do you want to give us just a quick rundown of, I feel like we need some pointers on, we need to be very specific about noun versus verb, practice, office, location, and should that be a focus today, or just taking into light our last final order that came through?
Yeah. Well, it may be easier to discuss in the context of like a specific regulation, but, so maybe we go there ultimately, but that is a discussion that we've had. It's probably a past version of this board. I'm thinking last fall is probably the last time we had touched on that topic, but yeah, at least that's been a focus, if you will, that we've encountered arguments. You know, what is a practice, and what does the practice of optometry encompass?
And so I think just have awareness while we're going through these that some of the holes in the legislation is because sometimes we refer to practice as a verb, and sometimes we're referring to practice as a noun, and that's where we find loopholes in. So hopefully by adding details, we can just explain the board's intent more clearly.
So can I ask a question along those lines?
Sure.
Like with our person that proposed today, who in another state's working under someone else, I mean, if they're actively doing the exam and everything else, doesn't that kind of enter into this too, if they were here doing that? You follow what I'm saying?
I'm not sure of your question.
So the one that we had applied today that wanted to be bypassed, he's working in Texas, whether you call him a super tech or this and that, but he said he's performing all the exams and he's doing everything else. He just can't sign the chart. I mean, wouldn't that kind of violate what we're looking at right here if it were in this state?
Yes.
Yeah, you'd be resigned to your delegation statute, 65-1508, as far as what duties can be delegated under supervision and what can't. And I don't know what he's been doing, but I'd be interested to know any difference between Texas law and Kansas law in that matter.
So do we actually, in the current verbiage, say what can be delegated and what can't?
Yes.
Okay.
Although I don't know if that's in our update today.
I just saw it based on the middle line of what we're getting ready to look at.
It's statutory.
Ah.
KSA 65-1508 is the statute.
All right, so I think let's get started on 65-10-1, which is practice locations.
What was the idea on what was struck through? Like, what was the intent? What was the history of that?
So for example, you have optometrists that work at the VA system, and with the VA, you can have a Kansas license, but move to the Texas VA and your license is still valid.
Okay.
So I think with the idea that you are an employee, not a owner of a practice.
So along the same lines, we have government clinics in Coffeyville, actually, most of southeast Kansas. They employ dentists, they employ others, but it's a government finance clinic. How would the practice of optometry work within that? Is it like the VA? Or how does that work?
I assumed it is considered a medical facility.
For instance, an optometrist can't work for a hospital, being a medical facility.
Could, yeah, that's permitted.
Pardon me?
That is permitted, yeah.
Which one?
Working in a medical facility, I mean, there are definitions of, you know, what would constitute a medical facility or medical care
Could you be
facility.
employed by there?
Well, like, so there are optometrists at Children's Mercy Hospital
On the Kansas side or Missouri side?
on the Kansas side.
There is, okay. That's right, all right.
Yeah, that's permitted.
So
By
what if it's
statute.
for instance, with our, I forget the terms, it's community health care, SEK, something along those lines. But it's a federal facility. There's no ophthalmology in there. We're at Children's Mercy. They're working under ophthalmology. So would that be permitted?
Yeah, it would be. I mean, they would fall within, I think, either medical facility and medical care facility. And both of those terms are defined by statute.
Okay.
I don't know if what you're getting at is whether a hospital could actually employ an optometrist. I don't see why it couldn't.
It's a community care clinic that's owned by the federal government. And I just didn't know, I mean, to me, that was a gray zone, and in reading this, I didn't know.
Now, I think if that facility was owned by a private equity,
Yes?
then that's a very different answer,
Okay.
because that private institution may not, may be considered as, you know, practicing optometry without a license.
Right, well, and I know it, I mean, it used to be, or the concept was, it was defined, you could work for an ophthalmologist, you could work for an optometrist, but you had to work for somebody in the like-minded field, care continuity type thing, where that clinic wouldn't have that. So whether it's a county clinic or a federal clinic or this and that, that's why I'm asking how that falls, or if it just hasn't been defined.
Yeah. No, I mean, that's a great point. There is, I think, a fair amount of detail in the law, not necessarily in the optometry law, but, you know, as far as the licensure of a hospital, for example, or a medical facility or medical care facility. And I think maybe the relevant point here is, you know, assuming that licensure at the entity level is fine. You know, you're really going to be looking at the scope of that license and whether or not optometry would be permissible under the scope of that license.
Okay.
Yeah.
I think moving forward also, allowing the statute to stay intact so that commercial entities are not claiming to be medical facilities.
Well, and that's why I was asking if ownership made a difference. I mean, I would think VA being a federal facility, what I'm talking about being a federal facility, that probably sets it apart, but that's why I was asking.
Mm-hmm.
So I'm going to bring us back to 6510.1. And so just reviewing this, I'm going all the way down to subsection 2. I'm wondering if we should just expand the wording, the licensee's practice is being carried on as a part of association with the business enterprise. If that needs to say the licensee's office location and practice management? Or am I making the, am I going too small here?
Yeah, I think what you're getting at is what's the meaning of practice, and Really, if, for this discussion, I think you need to look at the statutes that's being implemented, which is KSA 65-1502. And I can pull that up and give a little bit of a rundown, but I mean, this is an argument that I think the board has encountered is, I mean, it really gets down to the essence of what's the meaning of practice. Is it simply just patient care? Or is it what you would typically associate with practice as far as the office functions that go along with it? And I think the discussion with the board is that your practice is a lot broader than simply just seeing patients. It gets to everything that you do with your EHR, your records, scheduling, whatever contracts you may have in place as part of your practice. But that's been the argument, is try to isolate some of the incidents of the optometry law to not apply to those other functions. And so when you're looking at, I think, this whole group of regulations, 65-10-1, and also 10-2, which gets to unlawfully maintaining an office, you really need to focus in on the language of the statute, which defines what maintains an office for the practice of optometry means. And it's not very definite in my opinion. I think it's pretty loose, and of course, statute hasn't been addressed since 1990. Your regulations haven't been addressed since, I think, a similar time period, and they haven't been modernized to reflect, really what the practice of optometry is today. So you look at maintains an office, how it's defined in statute. It's one, to directly or indirectly control or attempt to control the professional judgment or the practice of a licensee. Or two, to bear any of the expenses of, or to have, own, or acquire any interest in the practice, books, records, files, or materials of a licensee. That language is relatively broad, but it's also not very definite. So one of the things that we've talked about is, do we need to define what the practice means? Because if you look at the way the practice of optometry is defined in statute, it's really just the scope. And you're looking at patient care, not necessarily, the back office functions that I think everyone associates to be part of the practice. Another issue to consider there too, and maybe we're getting a little far afield from 10-1, but we'll go there. To bear any expenses of or to have, own, or acquire any interest in the practice, books, records, files, or materials of a licensee. You then have C, which says that nothing shall be construed to prohibit a licensee from entering into leases, agreements, mortgages, or other types of debt instruments, not in violation of this section or any other section of the optometry law. I don't know that you have a regulation which addresses that specifically.
I guess I'm not sure if you're saying we don't need to be specific in the regulations because it's not specific in the statute, or we need to be more specific in the regulations because it's not.
Well, I think what you can do is you can attempt to flesh out some of the general nature through more specific incidents in a regulation, as long as it's consistent with the language of the statute. That's ultimately going to be your charge. And so I wanted to look at the statute just to give you kind of the framework of where it's broad.
Can you read the statute again?
It's 65-1502. And that's where maintaining an office concept comes from. And so then that's where the, sort of where the regulations derive their authority from, is 1502. So I think just kind of hopefully to distill this let me know if this isn't making sense, but, so 1502B1, I think one of the things that the board has previously talked about in discussion is, do we need to provide some sort of specificity as to what the practice of a licensee is? That's different than simply just the scope. It encompasses everything that you do relating to patient care. It's not limited to it. C talks about how there are permissible agreements or contracts that an optometrist can enter into. That's certainly something you also could focus on as far as trying to identify, because you see a lot of situations that involve a management services agreement where functions are being contracted to a non-professional entity to perform. And so is the line simply just, an optometrist can be set up to perform, purely patient care and everything else is delegated out, or are there incidents that the board needs to be focusing on to make sure that, professional judgment, professional practice isn't being impeded by, various incidents of that contractual relationship?
So where do we go from here?
Yeah, so, and then I guess kind of hope maybe to complete the circle, and let me know if anybody has questions about where we're at. So then you look at, the regulation in front of you, 65-10-1, which we're getting into the maintaining an office concept in subsection B. No licensee shall maintain an office or practice location. I have a comment there about if you strike indicates or implies and replace it with permits, I think it actually weakens the regulation, because it's more, if it's permits, I think it has to be, it has to be true, as opposed to indicates or implies. Sort of gets at the nugget that we're concerned about is there may be a contract in place, but what is the influence of the non-professional entity on the professional? So, if the approach is to change that standard, I think you really need to think about what the result is. And then, I'm not sure that this regulation is as much the concern as it is the next one.
I guess I'm looking for consistency. So I hate to change wording in one and then not apply that to, previous regulations.
Yeah. One thing you could do, because I think the meaning of the word practice, maybe I'm making too much of it, but I think it is something to think about. Do you need to define it in regulation? It is different from the scope meaning. And so do you need to define it as far as, here are the incidents that the optometry law considers to be practice? It's a lot broader than simply just patient care.
Because with the Corporate Practice Act, didn't the accountants get into that years ago as far as who could own and who couldn't own and influence over that?
Yeah, they have their own. They have their own now. The accountancy law, it requires CPA majority ownership, and then the minority ownership, they have to be natural persons.
Because I was thinking IT or somebody was trying to have ownership of some of them, so, yeah.
Yeah, well, that issue has popped up in the accountancy world. A lot of nuance, but I do represent that board, so I'm currently in the middle of that one.
So you think that we should define the practice of optometry aside from what's already defined in the statute?
Well, I think that's an option, yeah, because, if you look at the definition of practice of optometry in KSA 65-1501, it's really just what the scope of practice. I think that's the general meaning of the term. It doesn't necessarily get to you know, what in the industry now you would consider to be, you know, your part of your practice. Yeah. So I think that is an option that you have, and it would modify then, I mean, that you need to be careful here, but it would modify the meaning of, you know, B2, for example, the licensee's practice. It would give meaning to what exactly we're meaning by practice.
Does it matter where that definition goes?
I think it should go into your definitional regulation, which is, yep, 65-4-1.
Do you think we should amend the office or practice location or add a management section? That's section M, defines office or practice location.
We're looking at 4-1 now.
Mm-hmm.
I think, I mean, our discussion had been previously that, you know, we could think about actually defining the term practice. It'd be different than what you find in M. I mean, that's really more the focus on
The structure.
yeah, trying to define actually where you are, because there are different ways that optometrists practice. I mean, the mobile, for example, I think that was necessary from that perspective.
All right. So why don't we at least table the definition portion? And maybe Dr. Walters, that's something you and I can work on, is coming up with a rough definition that you guys can look at the next meeting. Does that sound reasonable? So usually we just try to whip something up and Tim comes and slashes through everything. So do you think we should wait on 6510-1, or do we feel like those are two separate issues?
I think we should wait.
All right, let's move on to 6510-2.
Do we need to wait on that one also?
I know.
Definitions, yeah.
Maybe we just read our definition now.
Well, so I think, I mean, some of the things that you can focus on, and I'm not coming with any solutions today, maybe, but at least to get you all thinking about it, you know, hearkening back to the statute 1502, you know, again, that's sort of been the response I think that you sometimes get as well. It's not an issue because we've contracted it, but we've retained any professional judgment. And so I think some of the things that you could look at are, you know, treating some of the incidents that are concerning or addressing them. So under subsection A here of this regulation, where, you know, we're defining what it means to unlawfully maintain an office, which is an extension of 1502, is to identify, I mean, if there are specific things that that the board is concerned about that are being contracted out, or maybe it's a totality of things. You know, that's something I think that you could look at, you know, as far as attempting to draw a line or implement a standard that, you know, ultimately you're going to be putting practitioners on notice of, you know, here is what is permissible, here's what steps over the line and violates the standard. And as we work through this, I think we have general concepts, but we don't necessarily have specifics, and that is something that you could delve into. And there, I think you're looking at, if you have someone who schedules for you, and maybe you're concerned about who it is that's doing the scheduling, or who's advertising for you, or other management services that may be contract out. You can certainly address those. It's not, I don't think it's going to be an easy thing to identify, but ultimately I think you need to look at the incidents if this is an area that the board wants to pursue, which step over the line of something that may be permissible from a management perspective that gets into and influences the practice professional judgment.
So you think it's necessary to say it is acceptable to hire a company to do your payroll, it is not acceptable to hire a company to do your scheduling, and they favor a doctor or something like that?
Well, are you concerned about it? I mean, to a certain extent, if someone is scheduling for you, they're dictating, you're dictating the practice. Yeah. And maybe that's too general in and of itself, but there could be a lot of nuance there, but I think that is definitely a consideration. I mean, if someone is set up simply, if an optometrist is set up so that they essentially don't have any meaningful control over their schedule and they're being dictated, is that a problem? Is that impacting their professional judgment, their practice? You can make an argument that it is.
Because you could say that we're dictating, you can only see these types of patients, and we don't want you dictating seeing those type of patients, things of that nature, so they don't put them on your schedule.
Well, there's a good example there from North Carolina. Dr. Birchie, you've heard it. You probably heard it too, about my eye doctor removing dilating drops because their optometrist said, no, we're not going to limit our practice that way. So the PE just removed the drops completely to take it out of their hands. And so, I mean, I think that should be the focus. It's not trying to prefer anything over another. It's, what's the line as far as trying to safeguard, patient care at the end of it.
Yeah, it's a little bit tricky too because, for example, if Dr. Beaver has an associate and you're his boss, then I think there should, at some point defining what, he should be entitled to tell his employee what to do.
He's a licensed person.
Still be a licensed entity.
Okay.
Yeah, and that's a great point because that's falling within, but that's the nuance I think that may be difficult to address here. But it's a really good example because when that falls within the, it's either under your own name or a professional corporation LLC,
Right.
it still falls within the, the entity that's authorized to practice. But it's the non-professional entity that would be concerned about.
Okay.
Yeah.
So I know for sure there are some things we definitely want to wrap up today. When you look at 6510.3, we could go on for days and days on this one. I don't know if we want to wait for our definition first. We have discussed this one in detail already during a meeting, and this was our final draft, and I think it's time now, after our final order, to relook at it again. Tim, I don't know if we can talk about that case or not.
Yeah, we should probably hold off until there's some finality there.
I think overall, although we may read this section very specifically, it can be interpreted very differently. So do we add more specifics? Are we pigeonholing ourselves by adding more
Yeah.
specifics? It's challenging.
Well, and as we've discussed too, you have the North Carolina Dental Board issue where you need to be careful that, you're not, and I think it would be incidentally, but you're not incidentally trying to favor certain, groups over others. You can't limit competition through what you do. That can be done through the state, through the legislature. But it's a question of, do you have sufficient oversight over the policies through some kind of legislative directive? And so that's something that you always have to keep an eye on, and it should be fleshed out in the review when it ultimately makes its way to the AG, but, that's still a question. Does it make sense to assign those group of 3 to same persons and have them review and take a fresh look?
That? So you and I would go ahead and take 6510, 1, 2, and 3. Okay. Peel them apart. All right. So if we move along to Part D, which is 6584, this is something I think we can accomplish today. And I would like to look at the statute on this one as well. So the regulation is 6584, and then the statute is, the definition is still, is still in 65.4-1. And so I had a phone call from, through Jan that came through. And there was kind of a surprise to me that there is no notation of expiration date. So I found it for contact lenses. I never found it for spectacle contact lenses.
Oh, there it is, okay.
I don't know if that stipulation was there before, because you have the patient that calls and they're in Italy and they broke their glasses and they're 30 days out. Do I have the discretion to say, yes, I will extend your prescription until you can come back to the
I
study?
think you would, based on having the chart that tells you the health of that patient and the health of different patients is potentially going to have different expiration dates even based on the condition.
And I would agree. I just don't know if that's why that statement was put in there versus just. Legally, how much of that an issue? Like for us to make.
I can't tell you on the law exam, it's one that almost everybody misses. Because the answer's at the doctor's discretion, and they all either put 1 year or 2 year.
So technically, they're not missing it because that's their discretion. As to how to
Yeah,
answer
that's
that
true.
question.
That's true, but
I got,
either that or you guys need to rewrite the law exam.
I got something on here I'd like to leave out, and you can ask me why, but
Go for it.
I think we ought to leave the PDs on. And here's why. So you have a patient who's had their ocular health exam, they've needed no correction or something along those lines. After the fact, whether it's 6 months or within reasonable exam time of that, they want you to send them a copy of it. You've never filled anything for them, they've never done anything for them, you don't have PDs on file. So you fill out a script not on file, and anywhere they're filling it at has the ability to measure the PD. So I'm just saying. there are some-
That's one of the, actually, next to expiration dates, it's always the PD that people are leaving off.
Yeah, but I'm just saying, whether you're sitting there scanning them because of the type of lens they picked out, because of the type of frame they picked out. I mean, when this was done originally, PDs was a ruler being held up. And you could still do that, but there's some lenses that require more of a customized fitting at that time, and you're not measuring that patient for it and everything else while they're there. So I think that this is, can you give it an answer? Sure, but it's not, it should be appropriately done by whoever's filling the script at the time.
Because I've also had a doctor tell me that the patient's better off if the optician does it, because she doesn't do them very well.
Well, beyond the ability, I'm just saying.
That wasn't her exact words.
I
but
think that
rather-
some custom progressives and things require a fit, and that's part of it. And if you're providing that fit, you should be the one taking the measurements for the PD.
I think that is, I would agree that it is a measurement that is rarely done by the doctor. And in this day and age, with all lenses, even single vision, the technology available
Has changed. Yeah.
Do we have any concerns with striking number 6? Todd? I see.
My only thing is you may get pushback from vendors who are online. People order a lot of lenses online and they don't have that information. They may not be able to fill it correctly. That's just a concern that I think you will hear, but I could be wrong.
I have no concern with that. Any other concerns with striking number 6? Nope.
Why is it there in the first place?
Because back in 1992,
So I can tell you, there are practitioners out there that instead of prescribing Prism, they change the PD. So if you don't actually use the doctor's PD, the prescription will be wrong.
Well, and we're not telling the doctor that they can't put it on there.
Correct?
we're just,
We're telling the patient that the doctor doesn't have to put it on
Yeah.
there.
yeah, you're telling the, yeah, we won't go there.
Because based on the fit of the frame they pick out and everything, I think that that should be done at the time that that's done. Because we will sit there and scan the patient, the appropriate measurements with the frame that they're actually using, and it adjusted and everything in place to get more accurate with the newer technology lenses. So if you feel, I mean, or any provider feels like they want to put specific ones on there, they're still allowed to.
It's just not, won't be required. And so when it's left off, I won't get the phone call that so-and-so left this PD off the prescription.
Just like on my scripts.
You'll still get the call. But you'll have an
But then I'll say, hey, the board redid that reg and it's no longer required.
No longer required, and they'll ask you, okay, now what do I do? And why isn't it required?
So if you go online, they give you directions to do it.
Just like with my
Credit card.
scripts, I mean, I'm
Sure.
specifying lens types with progressives and everything else so that it's not being substituted, and that's not in here, but, you know, I'm trying to give as much specificity as possible. But anyhow, that's why I said that I realize it might bring something up, but I think it's to just give a simple PD, binocular PD or whatever is archaic.
And we're prepared to vote and make that decision now.
And you would always have the discretion to change it. I mean, part of the process is, you know, it gets worked for grammar and legality, but then you open it up for public comment and you can receive comments. Hopefully, if anybody's interested in it, you'll receive the information and you can take it into account, you know, through the final process. Because ultimately, you'll move to a public hearing where you'll make the decision of whether or not to adopt the amended regulation.
We get asked that question a lot, I think, is, you know, people in the chair who we know are going to order online is, okay, make sure, you know, you got the PD on there. And I know some doctors are going to say, I'm not required to give that to you. And by removing that from our contents of a prescription, are we, on whose behalf are we acting?
It's a tricky thing with glasses in general, because I mean, the same thing could be said about seg heights. I mean, people are ordering progressives online, and you can't measure a seg height that way, but they're doing it. So, I mean,
But a pupil distance is specific to the patient, where a seg height is specific to the frame.
Well, the pupil distance is even on here somewhere. It says appropriate to the working distance of the prescription. Well, depending on what they want to take your script and get it filled for, that working distance can be a variety of different things. So therefore, it should be measured at the site that it's being fit.
So the blue things on here are the ones been added? Okay, so the original reg just said inappropriate.
No, I saw that, but with what was added along those same lines, you know, if that patient's wanting to take that script and get a reading pair or this and that, I mean, your PD is going to sit there and change. It can still be done off the script. So that's why I'm saying anywhere, anybody that's capable of properly fitting that lens at the site the patient is purchasing it is capable of measuring what that alignment should be. And to me, that's part of not determining the prescription. That's part of actually physically fitting the lenses in the frame. So anyhow, that's why.
I don't disagree with you, and I do think that when you, the reason I think that this was added, I may be wrong about this, but I received a complaint from somebody in my area saying that Walmart won't fill a prescription for distance-only single-vision glasses without a near PD, you know, and so I think that's probably why this blue was added. I think removing the requirement for pupillary distances is probably controversial, you know. I think to specify, even to say, provide a distance pupillary, and then, or, you know, for I don't know what
Well,
the
they also won't fill one for a specified lens type and design until I had to educate them and had their lab on the phone saying, well, yeah, we can order that for them. We just don't have it in their system to input. So, I mean, they can pick and choose and nitpick that all day long to try to skew what the patient's wearing. So I don't think we ought to be doing things just because any specific entity doesn't want to use this or that or something else.
I agree, we don't need to be providing, you know, monocular pupil distance far and near for every prescription.
Yeah.
Right? That's not something that we measure. I just can't see a scenario where there's a lot of people do business brick and mortar rather than online.
There's a reason why half the online stuff doesn't work. So potentially you're providing a service to patients just because they think that they know what they're ordering and how it needs to fit, but they're not. So they end up wasting the money when half the time it doesn't fit, even with everything in place. Anyhow.
I can leave that struck.
I think for now, and we'll simmer on it.
Okay. Okay. Can we move on a little bit?
Be interested to know if other states have that, have pupil air distance as part of their prescription.
I did a survey. I'll have to dig it out and find it, but I did a survey what's contents of a prescription, and it varied. But
There's a lot that don't, because they'll say it's $50 for a PD measurement, so.
Wow.
It's pretty common for them not to have it included, I would say.
And ours has been in there for 30 years.
Probably 130.
Yeah, I'll find that survey that I did and send it out. Because there were some states that didn't do it at all.
Some online places will even offer to reimburse patients to go pay to get their PD measured.
Really? Yeah. Fascinating.
So where was the line in here about solutions?
Oh, it's coming up. Oh, and they also pointed something else that's not in the reg, but it's in the statute, but we haven't got to that yet either. They were becoming my best friends a couple of weeks ago.
I get to hear all this, so. This is a, if
you didn't know that.
not a daily discussion, it's a weekly discussion, right?
Yeah.
Mhm.
I cringe when I see that on the caller ID.
Me?
No.
It's okay, I didn't know. To clarify.
I am pretty happy with the hard and soft contact lens information. I don't see any additional changes from what's already.
Okay.
Any other comments on contact lenses? And then I think the big question will be the expiration date. Do we, sorry, Jan, I am at.
Hang on.
Are we leaving the patient's name and address and phone number on there?
Yeah, that was something else that was just brought up the other day, is that in the reg, it just says patient's name, but in the statute, it says patient's name and address.
So we can't change the statute, right?
Okay, so I guess we're leaving it.
That's about where we were.
Well, F2 is telephone number. Oh, no, that's, I'm sorry, I'm on the wrong one.
No, flexible. Okay, there. That's the manufacturing, says the suggested sterilization state. That one needs to go bye-bye.
Yeah,
Which
Walmart
one?
didn't want to fill a prescription for daily disposable contact lenses
Where are we?
because I didn't have the manufacturer suggested sterilization.
No way.
Yes,
Absolutely
yes,
true.
yes.
Why are your Walmarts so picky?
There's one in Kansas City, too.
Oy.
She said I spoke to the manager. I haven't had any issues since I discussed that.
No, but I was getting not only phone calls from them, but from doctor's office saying that they were like being harassed by them.
Oh, yeah, I would definitely say that.
And I just usually just email the doctor, said, hey, this is, you know. everybody good with the, what's,
I guess I need to print my license number on my screen.
yeah, that's required. They haven't caught that yet? Maybe I should make you take the law exam.
I passed it.
Yeah, same here, Gary.
It's probably on display like it's supposed to be.
In the statute, I think in definitions for prescription, it does say name of patient and address. So we probably need to put an address on 3. That was just something that was pointed out to me like last week. Because I looked at the reg, it's not there, and they're like, oh, no, that's in statute.
If it's in the statute, does it need to be in the reg? Or is that redundant?
Well, since everybody looks at the reg for it, it probably wouldn't hurt to have it in the reg, just,
Yeah, because otherwise you have to engage a little bit of legal interpretation.
Yeah, okay.
So having it in the regs probably.
because usually I just print out this reg and send it to people. And like I said, when they said address, I'm like, well, it's not required, because that's all I looked at. Oh, no, that's in statute. So, I did verify it is in the statute.
Most of our
So you did
EHRs
add that already?
Yeah, I just put it under 3.
Most of our EHRs do that automatically, but I'm sure when this was written.
So when you guys were talking about the telehealth thing, you struck out, where the prescribing licensee can be reached for consultation. That was something that was struck out. And that was something you guys were talking about, where the after-hours type thing on the telehealth. I know, 2 different things, but
Should we put and address in front of the patient? Sorry.
Yeah, I agree.
Instead of the name of the patient and address, the name and address of the patient.
And that's the way it reads in statute too.
I was going to say, I'm sure when this was written, writing something else down on the pad, on the prescription pad, there's probably a reason that wasn't put in the reg.
Oh, yeah. That's a lot of just doctor scribble, yeah.
I would still say that there's some people who.
It's an electronic transmission.
Right, I mean, it's not an issue for most of us, but I know some people still write out prescriptions.
and put expiration date instead of if appropriate.
Are we okay with not specifying a time? And the answer is still at doctor's discretion?
Yeah, but at least have expiration date.
Yeah.
And then you say, well, that's what the doctor said, that's what it is. Because my
Right.
doctor will write him for 2 years before it expires.
Go ahead.
So can I make a question for you?
Sure.
The part about the no prescription issued by a licensee for rigid or flexible, whatever it is that says they can't pull it from a spectacle prescription for a contact lens. Should we also, or you also add something about they also can't pull it from an expired prescription?
But it does say existing lenses, so maybe we add there existing lenses or expired prescription.
Yeah, just something, because I know that is an issue where prescriptions for contact lenses are being billed using expired lenses.
Am I on the right page then?
We're below where you're at.
Yeah. Is that where you're at?
And so this is referring to the doctor giving the prescription. So you feel like doctors are giving prescriptions from expired prescriptions?
No, I guess I'm thinking, I'm not thinking the doctor doing it, I'm thinking if somebody orders from somebody, so maybe that's a different place for that, but just, that is an issue that shouldn't be allowed.
I think he's thinking it ought to be more defined.
Maybe it's somewhere else.
I just don't know if it's necessary here, if we already have, you know, the doctor shall not include instructions to obtain specifications from examination existing lenses. I don't think it'd hurt to add expired.
Oh, here it is. Any prescription.
Yeah.
Yeah, because I think that's more it. Not include requirements for flexible or rigid contact lens shall not become adequate prescription.
Somewhere on here it said quantity too on contacts, didn't it? Did I miss that? I thought I saw it.
What was your question?
As far as quantity of contacts in the prescription, I thought I had seen it.
So that might be, there is a separate section on the federal requirements for doctors to release the contact lens prescription. It might be in that
Might be
section.
not. Should this reflect what that says? Because I know some entities are 2 days before the prescription expires, trying to sell another whole year's worth, which circumvents the expiration date. And if the prescription contained quantity, that should be consistent with the expiration date.
I don't know if that matters if they're buying their lenses from different entities. The statute does not include a quantity.
Does it include like replacement schedule? Is that on there? Am I not seeing that?
Because in the drug section, you're asked to give the number of refills, the expiration date, etc.
So I'm referring to the statute 65, 4966. And really, the only stipulation is that the contact lens expiration is 1 year. And that you have to disclose the, information about the lens.
Sure.
Sorry, where are you looking? Which statute?
This is in the statute, 65, 49, 66.
That's not one we're reviewing right now, correct?
I'm just referring because this has to match the statute. Yeah.
I got you, okay.
I just wanted to make sure they were consistent. I'm not sure I'm that picky about the quantity, knowing I have patients that wear monthlies that change them every 2 weeks. And, I have, I guess I think that's up to my discretion, not the manufacturer's recommendation.
And I'm not disagreeing with that, but what I'm talking about is I have patients wearing dailies that are changing them every day that are solicited to buy a whole nother year's worth 2 days before the expiration date. So that's somebody circumventing my expiration date. So that's why I think the prescription, whether it's me or anybody else, ought to give an expiration date and a quantity associated with that. Just like you would a pharmaceutical that can have an effect on the eye, so can that contact lens without being observed.
Creating a lot of extra work for
Or less. Because I'm putting quantity and expiration dates on my scripts anyhow. It's just, I don't think we have as many ways to enforce it if it's not part of in here.
I think it's a lot of trouble for a largely non-issue, if I'm being candid, but
Okay.
that's my opinion. I don't see that a lot in my practice. I don't pick up from other members.
I think maybe the theory is too, nothing's preventing you from putting it on there.
Yeah.
But we don't
That makes
necessarily.
sense. That's kind of like earlier, yeah.
That's true. And people can go buy a year's supply from 10 different suppliers too if they want to.
And that, yeah, that's true.
So we're still coming full circle to expiration date. We're going to leave that the same. Do we think we need to add any, 99% of, one, this only says topical pharmaceutical drug, so I don't know if we want to add oral, but 99% of those are electronic now. Oh, I'm sorry, I am at G. H, and then subsection, all of those, it just, I don't know if at some point we need to refer to, electronic information or if it's just not necessary.
So you're proposing just to remove the word topical?
Or adding oral.
Can you just say ocular medications?
I think just removing topical would probably take care of it. Because I'm in pharmaceutical prescription.
So do you want to strike topical, Jan?
We're in H, right? I mean, one of the issues you have is that's a term that's defined in statute, topical pharmaceutical drug. 1501A. I think that definition also requires the name and address of the patient to be included in the prescription.
I'd scratch that.
So in the statute, it does say prescription for topical pharmaceutical drug or oral.
So
I think you got to just remove topical because of the changing nature of drug delivery.
Well, I think Tim is saying we can't because it's in.
Yeah, I mean, it's a term defined in statute. So, I mean, if you want to include oral, then include oral. Because, yeah, in 65-1501A prescription for topical pharmaceutical drugs or oral drugs is defined. So that's the concern, is that oral is not included. You can certainly could include it.
And I mean, this sounds ridiculous, but it says the printed name and license registration number. Nothing is getting printed. I mean, these are nuances, but does it matter?
For an electronic? I mean, I think you could make a pretty good argument that, I mean, if it's printed on the electronic version electronically, that it's printed.
Okay.
But you're not wrong, it's antiquated.
Yeah, it's very antiquated on.
It's people, they take their whatever script from their phone, because they download it from their app, and then they take it in, and it's missing all this stuff. So I've seen that, I've heard that.
We're not that fancy. We don't know how to do that at my work.
Because I've heard that. It's like if they print it from the app, the script from the app, it's missing items that would be missing if they handed it to them at the office. Or at least that's what they tell me, it's what it is.
Good to know.
Did you want to add oral drug to H?
I did up there. I took out the A and just put for tropical or oral pharmaceutical.
I think, Jan, you need to, I would do it consistent with the statutory definition.
Does it say A?
It's topical pharmaceutical drugs or oral drugs.
I could have left that there.
So I seem to recall, too, that there was discussion about changing drugs to agent at one point in time. Do you remember that?
Yes,
Last fall?
yes.
So, I mean, if you were to pursue something like that, it would need to be a statute change. You couldn't affect it by regulation.
I don't remember where that blossomed into our conversation. Except for that we can't do it yet.
I don't either. I might have it in notes, but
So any prescription by licensing for topical pharmaceutical or oral drugs?
I think it needs to be topical pharmaceutical drug or oral drugs. That would make it consistent with the statute. Yep.
When we're sending this through all of the systems, are they actually comparing them side by side? In theory?
Yes.
Yes.
Yeah.
Just curious.
Sometimes ad nauseum.
Uh-huh. I had issues with the last one that it got through D of A, but it was missing punctuation. And the AG's caught it, and I had to 3 times through the AG's office to get it.
I feel like this one looks pretty good. Do we need to approve it one more time without the strikeouts and additives, or can Jan just go for
When
it?
I send it, which is why I kind of did it the way it's kind of done, is that it has to be double spaced. Anything I add's got to be underlined.
Oh, gotcha.
Anything that we take away has to be struck. And so all I have to do is, when we get done with this, is take out the red and the blue, and it's ready to go.
Gotcha.
I was trying to make my life easy when it came time to.
Yeah, absolutely. I'm checking it off the list. 6584.
Okay, so I can send this one through?
You want to have a motion to ask Jan to initiate the process, I think would be the correct motion here.
Would anyone like to make a motion?
I will make a motion that 6584, that the changes discussed today be presented to our executive director to be worked and adopted.
Do I have a second?
Second.
All in favor, say aye. Aye. Opposed, same sign. And motion passes.
That one started then.
All right, let's chug along to 6541.
I thought that we were tabling that one. That one's definitions.
Oh, hold on, let me look at it.
undergrad practice.
Are there any other definitions we think we need to tackle besides the practice? It's pretty good overall. We spent a lot of time on this with optometry.
Which one are you on now?
Oh, I'm sorry. I'm just briefing through 65-4-1, just to see if there are any other definitions that we want to look at before, if we table this for next time.
So I think there's some that I had some comments on.
Okay.
And Jan, is this the version with my comments or the?
No, it's not.
Okay.
You want me to pull that one up?
It may be easier to look at the one, and I can just talk about the sections. But if you scroll down to W, yeah, so this is where the topical pharmaceutical drugs was modified to pharmaceutical agents. And I think you need to stay with the statutory definition, or at least the term.
So stay with topical pharmaceutical drugs.
Yeah.
Or oral drugs.
Mm-hmm. And so in that vein, you know, I'm not sure the other changes to that definition make sense.
You mean, what we have already struck, or?
Well, so as far as is there a separate definition for oral drugs in the regulation? I don't think that there is. No, there's not. But, you know, with there being a separate definition for topical pharmaceutical drugs in statute, I'm not sure you want to commingle the two. Or, you know, the language that which had been struck means drugs administered topically and not by other means. And so if you change that, you're really drastically changing the definition.
Are you saying we don't need to strike those out?
Yeah, I don't think it makes sense in light of how the term is defined. I mean, in statute, it's defined as drugs administered topically and not by other means.
We have a definition for oral drugs too, though.
Is it in regulation?
No, it's in statute.
It's in statute, right? You don't have to do it this way, but the way the W currently exists, it regurgitates the statutory language, means drugs administered topically and not by other means. And then you've expanded on the definition in regulation. And so the proposal, I mean, was to change it from topical pharmaceutical drugs to just pharmaceutical agents. But doing it that way, you know, I mean, I suppose if you're going to go that kind of a route, you need to say that pharmaceutical agents means topical pharmaceutical drugs or oral drugs as defined in KSA 65-1501A, and then you could possibly get on with your defining. Does that make sense?
I don't even know if we need W at this stage, because this was written at a time where optometrists could not treat glaucoma. So it had to be defined, you know. So, right, by striking everything out, we are saying so on my, we're saying they can use everything, and not limiting to anything but injections, which are not topical. So does it need to be in there?
Well, I haven't done a search of your regulations to see every place where it's used, but I mean, at the very least, it was used in the previous regulation. But that was just a prescription for a topical pharmaceutical drug. But you certainly, the statutory definition would apply if you would strike it from regulation. I guess that would be the issue, is where do you use it in your regulations? It may not be necessary.
I'm okay if we leave it, strike everything, and then do we need another subsection that refers to oral? I don't really think we do.
It may be a similar type of analysis with topical pharmaceutical drugs.
I think we just go down the route of our optometrist prescribing oral drugs that's not within their scope. And
Somewhere in there we had it written for ocular use.
in the statute, it is defined. But I think that's where the only, where this would apply is doctors not using it towards the eye. So I'm okay leaving it as is, going back to the topical pharmaceutical drugs. And then used for examination, diagnosis, and treatment of the eye. And then excluding injections.
And then getting rid of the 1, 2, 3.
Yep. So we reviewed that, and it just changes too quickly. Every year there's 3 more glaucoma drugs. Did you see one company's bringing back a dilation reversal drug?
It's out there.
Hmm?
That's out there.
You like that change in the definition? I also had comments on U, T, and U. And it's a minor thing, but there'd be a change from electronic to, or inputting digital. The statute says electronic. I don't know what the difference between the two would be, but my advice would be consistent with the statute.
Yeah, because we're not, the AG's office will be.
I think we want electronic, and we want to take out digital. Oh, gotcha.
Does the same apply for the deficiencies or binocular? Was that change made because of consistency with statute? Just at the end of T?
So why does that part not have to have topical and oral both?
Are you on U?
Uh-huh.
Okay.
What was the question?
So on U, that says where it first starts prescription for topical pharmaceutical drugs. Why does that not have to say topical and oral both?
Again, that one's almost word for word from statute as well.
I don't know. That's a good question. I wonder when oral drugs was added to the statute.
So oral was added in about 2000-ish.
I don't think this regulation's been touched since, yeah. So it just hasn't kept up with the change in the statute.
Yeah, so I'm saying while we're changing, why should we not add oral and topical?
Yeah, you're right. The statute, the term defined as prescription for topical pharmaceutical drugs or oral drugs.
And earlier, we made the wording reflect that same thing. So to me, this should as well.
Can I back up a little bit? I probably wasn't clear on my previous question on T. So at the end of T, and maybe this was discussed and I didn't hear it, but at the end of T, you've changed insufficiencies or abnormal to deficiencies or binocular conditions of the eyes, where the statute is more consistent with the original language. What's the purpose of that change, or what does that serve? Did I miss that?
I think it was more of a, I do not believe it. I cannot find a statute that it refers to. I think it has more to do with the language used, because we rarely would talk about a binocular insufficiency besides your convergence.
So is that change, is it consistent with the language of the statute? Because to Dr. Walter's point,
You pulled in the statute beside here, which was very helpful.
So the statute does say insufficiencies or abnormal conditions of the eye. So what the red is actually what's from the statute.
What's the purpose of changing that to deficiencies or binocular? I guess was my question.
I have no idea.
I think you were just trying to update language.
So prior, all of these regs were divvied up to other board members, and we would go through them and edit and then come together. So this is probably a 2 or 3 version ago. This is a Becky Sparks update, I'm pretty sure.
Nobody here knows the answer to that question.
But it sounds like we need to stay with insufficiency or abnormal. I was corrected.
So revert that back to existing. I'm sure there was a reason.
I will be honest, when I was first assigned my regs, I was not doing them side by side with the statute.
I don't think anybody was. I think they were just going through them.
Yeah. And so, since we know we will table this one for a new definition of practice and management, Dr. Beaver, would you like to work on wording for adding in the oral drug statements?
For this particular, so we're talking about 465-4-1.
Yes.
Okay.
All right, any other questions on this regulation?
And the statute we pulled that wording from earlier was?
KSA 65-1501A, and then a subsection G.
And then Q is oral drugs. All right, let's move along to 65-4-5.
Thought you were joking at your last meeting when you said that we needed to come in earlier because it was going to take a while to go through these.
Yeah. I think we did a whole day, pretty much. Yeah. That's what it looks like. The only thing that got changed was remuneration. Somebody said that we didn't have the right word in there. That's the only change that I can see.
My copy from the website, there's some changes in paragraph 2B.
I think I don't know if I can ask this question. Do we need to add details to this to provide adequate exhibits or facts to show that the doctor is not complying with these things? Meaning it has been a question of whether doctors can actually be accounted for this when they are taking appropriate steps. So I just don't know if we need to change things so that it's just very clear cut. The doctor did this or the doctor didn't, or the doctor did this, but he's not responsible because their attorney told them that they could.
I'll get on the right version of it. I was on the wrong one.
Oh, sorry.
Not your fault, mine.
I'm confused. Could you give me an example? What you mean?
I don't know if I can.
Okay, fair enough. Are you talking about in a multi-doctor practice when you're referring among yourselves?
No, I'm thinking that as a board, we look at this again and it's very straightforward to us. And then the court of law, are we able to demonstrate what we think is the wrongdoing?
Okay.
And
I got you.
tough.
Okay.
I don't know if this is one we would almost wait until after our order comes through.
Yeah, and I think this is one too, and it may be the best place if there are specific incidents that that the board should be concerned about between a professional and non-professional entity. I think this would be a good place to address it. Because this is where you say, if you go back to the maintaining an office statute, it talks about, thou shalt not influence professional judgment. Well, this is your professional judgment regulation. And so here's where you could get, more specific, with respect to the types of, incidents or relationships that we should be concerned about.
I can take this one under. I think it's just really hard to discuss without going into depth about things we need to wait on. So we'll table this one too. I will sign that one too myself.
Practical application.
I'm a little disappointed we are not accomplishing as much as I hoped. Does anyone need a break, or can we just plow through?
Let's plow through.
Okay. All right, let's move along to 65.5-1. This one seems very straightforward, but
I did have something. Need to make
Lawyer
it
gets paid to do this.
a lot more complicated. Well, so we have had situations here recently where the board's talked about the timing of the exam one time a year, and I'm not going to get the details right, but you have recent graduates, right, who they may take part 3 before they graduate, they don't pass it, they take it again, they don't have their part 3 scores by the time that the application deadline comes around, even though they've sat for it the second time. And so it creates a timing issue of those applicants wanting to sit for the exam, and the board has allowed the exception on occasion if you've sat for for part 3 but don't have your score. The board has allowed, I think on 2 occasions that I'm aware of, an applicant to sit for the Kansas exam. And so I think the question in my mind is, is that based on the timing of it, if you continue to have a state exam, does it make sense to list that as a qualification to sit for the exam as opposed to, just a condition of your ability to eventually obtain licensure? And that would throw the timing into question. Or you certainly could build in and I would suggest you do this if the board is going to continue the practice of allowing someone to sit who hasn't passed all parts of the NBEO exam. But from that you would need to build something in, because otherwise you're waiving your regulation, which is never advisable.
so my stance on this has never changed, but I think what influenced the board at the time is, one, we had 2 to 3 years of graduates that were COVID students, so they had limited clinical and/or classroom experience. And also in this time period, they have changed national boards. So part 3 must be taken in North Carolina at a testing center. The student is responsible for all of the cost of the traveling, the overnight, the fees. And there was an idea that maybe a hardship was felt upon the students because of that. I don't think this is any different than 10 years ago. If you didn't pass part 3, you don't get to take the test, period. That is just where I come from, but that is where the board weighed the decisions.
So
The board test is going to change again within probably 18 months. So we're going to have.
No, it's changing August of 2024 is when they're changing the format.
I know, I just think there's going to be a lot of hiccups between now and.
Supposedly they worked them all out, but that's the go-live date for the new exam is August 2024.
When was the last time we carved out an exception? Was that only during
Last year.
Last year.
last year?
Couldn't we put within a year of the board exam, and that would give them?
No. That's just
So-
my opinion.
So right now, our date is based purely on like the application on the website. We don't have anything specific in the regulation, right?
There is in the statute, I think.
I'm not
Is there?
entirely understanding the date.
Well, so like speaking about timeline, do we currently have any sort of specific timeline on when?
When they have to apply.
Yeah, thank you.
I think it's
Addressed in
within 30 days.
Is it? Is it right in front of me?
No, I don't think it's in that one. I think it's in 65-5-2. Yeah, 30 days.
Yeah, because last year we also had one that I got the exam results or MBO scores the week after the exam.
Not our problem.
So like, I know
It's one that did not,
like it doesn't happen very often, but what if they take, because are they guaranteed their scores by a certain time?
No.
So speaking as someone who had like my board 2 scores were delayed by months because of the cheating scandal at one of the schools. And so when you take your boards on time, but if the NBEO,
So realize it's a
Behind.
rolling date now.
Right, so, but then if they have no guaranteed timeline by their score date, like when do they decide when their last possible date is to take boards? To get scores on time? Let's say they take it in December and something happens and their score gets delayed by months.
So I'm thinking, because they take it in April, I'll have their scores by June, first week of June. So if they take it in May, I'd have it the first week of July. So it's like, what, 2 months? So if they take it in December, I should have their scores February. It's always like 2 months.
So the other thought is, and I'm just throwing food for thought out there, you have an applicant that has not passed. We allow them to sit for the Kansas exam. They do not pass Part 3 until a year later. You have someone who has not had continuing education for an entire year. Again, I'm just food for thought.
Yeah.
So, and then are we writing a regulation to the what-if factor? Which we can address if there is a what-if factor. I mean, if everybody's delayed, we could address that, but we would know that ahead of time.
I think that's been the situation with the COVID exceptions, right? I mean, this is a special circumstance.
They couldn't take it, and COVID was a mess.
I'm just not sure why we would change now.
Well, if you don't want to address that, another option would be to build in some kind of a good cause. You know, if you've passed 2 parts, haven't passed all 3, the board will allow you to sit for good cause shown.
I just feel like it's opening a can of worms.
Is there a problem with the way it is currently, but allowing those case-by-case exceptions? There is.
I think there is, because you're, theoretically waiving the requirement. And, what if you, maybe apples and oranges, but what if you treat somebody who may think that they're similarly situated differently?
And then you got a real problem if they pass yours and they didn't pass the other.
Yeah.
And that has occurred.
That's it? Okay.
Yeah, and it really makes it messy, but if you build in, like a good cause exception, then you could, on a case-by-case basis, address things. But then you have the mess of trying to, make sense of what is good cause, and so there would be a little bit of precedent checking from that perspective. But
Can we put good cause in for all of the qualifications, not just for board exam? I guess I don't want to give the perception that we are willing to give everyone a chance to take the Kansas board.
I think it depends on what you would be willing to allow the exception for. I mean, like, for example, number 1, graduate of an accredited school or college of optometry. Never had a license revoked.
So here's an exception that falls in with what you're talking about a little bit. From what I heard today, my college of optometry, you couldn't graduate from if you hadn't completed and passed all parts of the board. Apparently, the one earlier today, you can. So there's some irregularity right there. If I hadn't have passed part 1, I couldn't have gotten my diploma.
Is that still the case with other schools?
It's still that way with SCO. I don't know about other schools. Apparently, it's not the way it was with the one that our attendee presented with this morning.
So the other thing I just want to bring your attention to is, I think there's 4, correct me if I'm wrong, Jen, new schools/colleges of optometry. And the pass rate for Part 3 was 43%. That is down from the previous year, which was, I think, 89%. And so I feel like we really need to address this now, because I think we will have this onslaught of
Exceptions.
that because they're not performing well with Part 3.
So you're maintaining, or your position would be, keep it as is, we're done making exceptions because the global pandemic is over, basically. Am I right in saying
Yes. Yes. Again, I'm just very black and white, and I feel like we opened Pandora's box to.
Because we did have one last year that the week prior to the exam, he got his scores, did not pass, and he pulled his application. And he'll be here this next year in July.
So as
Because
it,
he's passed now.
He's passed now and I've got scores. But it took 9 months for me to get scores.
But I'm good with sticking with that requirement.
So do you think we should add something about a goodwill clause? Good
cause. That the board could grant an exception for good
If we
cause.
feel like we're done making exceptions, do we still need to do that?
Well, yeah.
Just always a way to give you a good.
Oh,
So what do you do? Put a line in saying, you know, the board will evaluate extraordinary circumstances?
yeah. I mean, something to that effect. If you think there's a standard out there that somebody could be allowed if they pass 2 parts to,
Well, I'm looking at it more like when she's talking about because of the scandal over the app that all
Yeah.
scores were delayed. I mean, I'm thinking of more like that, not necessarily a one-on-one basis.
And there could always be another pandemic,
Yeah.
heaven forbid.
yeah, I mean, you could make it for circumstances out of the control of the applicant, something to that effect. I mean, otherwise, I think the one you're always going to get is, you know, I failed it once and I don't have my scores back.
Yeah.
Yeah.
And, you know, does that justify it?
'Cause I have April on the board's website. It's the last day that they can take the exam, but I'll get somebody that they failed it, and they're taking it in May, and it's like, okay, that's the ultimate dead drop. You can take it in May, and I'd still get them,
But
but,
the thing I kind of look at, maybe if May you still get them, I mean, it's a sad situation that they failed it, but that's not our control and obligation.
okay, so at one point in time, the board had moved the exam to June, and it was like the first week of June. So I had renewals got done, the exam, and then I didn't change it toward, I didn't start getting scores until the day before the exam. And so it was just a headache. So I've kind of bumped that back to where I have some wiggle room, so I'm not getting
Yeah,
bombarded with
so
scores.
we can take that into account without putting
Yeah.
that.
That's why, you know, on the few that have called and said, oh, I'm retaking it in May, can I still take? And it's like, well, as long as I should have scores back before the exam.
so we need to be clear though, so when we respond to those questions, like, you can take it if your scores are received by this time. And if it's received after that, or not.
I think I've even had some that I've gotten the scores the day of the exam. Not very often, but, because I remember sitting during interviews and the exam, or the scores popped through the email.
Is that because you asked for them?
No, how it works, and you should know, you know, this, you pick the schools that you, or the states you want it to go to, and as soon as the scores are available, then NBO automatically sends them.
I just mean, you know, the instance where it came during the exam, where did you enter that weekend going, I don't have scores from this person, and following up with
I don't.
Andy, or is that just how the timing worked out?
Yeah, it's just how the timing worked out. I remember a couple of others that because MBO doesn't send scores until they graduated, it was a school that didn't graduate until like the end of May. And so MBO was delayed getting me scores because they were delayed getting the graduation stuff. But also the person at MBO that does send scores, she was on vacation. And so it was, I think I got them the Monday after the exam. But like I said, that's when the board kind of moved it back to July too.
There's always going to be circumstances.
So if we leave it like it is, do you want to add the line of board will evaluate extending or unusual circumstances?
How do you feel about that, Don?
Yeah, I mean, if it's going to cover us, I think that's fine. Tim, is that something you can whip up to make it official and legal?
Yeah.
Yeah, I mean, is it, what's the standard? I mean, is it circumstances beyond their control?
Can we just say extenuating circumstances?
Extenuating circumstances.
Or
But what does that mean?
We'll interpret that at the time.
Yeah,
Well, what I heard you say earlier, I thought was, a lot of people aren't passing this part through, so a lot of people are going to fall under this. I've taken it, waiting to get my scores back.
I think we're going to hear every excuse under
Yeah,
the
or
sun. My plane
it'll
was
be-
late.
I couldn't take
fish
it. I
on the
couldn't
plane.
get into schedule it until way late. I think that was a lot of this last year. They couldn't get in to take it. They couldn't get it scheduled to take.
At which point in time we said, great, when you get it done and get your scores, let us know.
Back, yeah.
Submit your application.
And I do know years past, they did offer the exam twice a year, in June or July, and then again at the first of the year. I did see that once when I was scanning through files. Somebody was graduating in December and emailed the board and asked if they, or not emailed, sent them a letter, asked if they could have the exam in January, and the board did. But that was way back when. I don't even remember who it was now. Learned lots of things scanning in all the files.
All right, let's move along here. And almost the same topic, so 65, 5-2.
Jane, based on any, there have been some changes to the application here recently, last year. Is there anything you can think of that should be included here that's maybe a change to the application?
Is submission of board scores under application? Like, is that not part of the application? Or am I missing that on here?
It should be under one.
One, okay.
Yeah.
Qualifications in the application. Board scores are not part of the application.
Right.
Is that kind of what you're asking?
Yeah. I think that's where I'm getting confused on the timing. Like, we have it listed as a qualification, but it's not required to be on applications 30 days prior right now. I mean, we can say it's under academic transcript, proof of degree, or completion of optometric program, but I don't think that, I think we should specifically say national board scores or something, right? Or no?
Yeah, that kind of brings the timing question back into play.
That the board scores must be in 30 days prior.
Yeah. Because what I tell people is like, I need the actual application itself. And then it's like, and I'll give them extra time to get me the transcripts and stuff, depending on the timing. Because I give them until like 10 days prior to get me the transcripts, if that's what they're missing.
Is timing the reason that it's not in this reg?
I don't know. I mean, the reg is from like, what, 1992?
So when this reg was written, part 3 was given on one day. And the whole nation took it on one day. Whereas now you could take it in October, you can take it in April. We actually have students taking part 3 before they take part 2.
That looks really weird.
It looks really weird. But, so maybe I don't know if the 30 days is, that's for you, Jan, because you have so much on your lap.
Sounds like it happens frequently where the board scores are not in.
Right, because the board, again, they're dependent on MBO to send them. MBO doesn't send them until they receive proof of the graduation.
Oh, I didn't realize that.
Yep, I learned that the hard way. It's like I'm waiting on scores and like, well, we have to get something from the school saying that they graduated before they send them out.
But should it even say something in here about board scores? It doesn't say anything right now.
Yeah, I mean, there's kind of a disconnect there because you don't necessarily have a complete application. But of course, this reg determines what's a complete application.
Yeah, and it used to, back when I started, and I think you guys were part of it, that you actually had to send me your high school transcript. in addition to, and then it wasn't so much, I had the transcript from the optometry school, but then we also required a copy of the diploma. But we did away with that. If I can get the degree conferred on the transcript, I don't need the diploma. And we didn't need the high school transcript.
One thing you could do if you want to add, because I think I do agree that it's a little bit disjointed with 5-1, because it doesn't address all the qualifications, is that under B, you have the ability to hold an insufficient application for lack of qualifications up to 1 year. And so technically you could, if you receive it 30 days prior, but you don't have all the board scores, then you could hold it pending receipt of board scores. And if they, it'd be similar to your process now. If you do get the board scores, you can determine then, 5 days, 2 days, or whatever it is before the exam that they're qualified. I think the mechanism's there.
I think that's what we ended up doing last year with a case that was like, they passed pending receipt of their board 3 scores, didn't we? And then it turned out to be a moot point because they didn't. Right, but if we do have that.
So where in here would you add the board score? Where which line?
I think you just add it as one of the A, 1 through 4, so you could add it as A5, I guess. Okay. Or you could bump references down if that's cleaner.
Okay.
And I know you mentioned concern about them not having CE for a period of time, but this says may be held by the board for a period of up to 1 year. So we don't have to make it a whole year. We could make it 3 months or something like that. If we wanted to put in something specific even for boards, I don't know if that would be complicated, but, or when we're determining timing, I don't know how often that particular section has been used.
So this is usually used if they don't pass a part of MBO by the time of the exam, then I just hold their application for a year, get the scores, and then they can take it the next year. Okay, yeah, because they're not taking the exam yet. Yeah.
So, but if you bump down 3 written references and put in there, including completion or passing of all boards. Or verified passing of all boards.
So here, I don't think we need to put that they're passing national boards as much as submitting documentation.
Correct, I agree.
Documentation that they took it, but not.
But if they took it and failed.
Yeah, because I don't get scores. I think last year, if I want scores from somebody that hasn't quite passed, I have to actually contact NBO and they will send them to me. So I have something so you guys could see something.
Because we're not saying they just had to take it, we're saying that they had to pass it.
Well, right, but here, like on the,
Just put national board scores.
I just don't know why.
Passing
on
national
one we're
board
not
scores?
adding national board scores.
On number 1.
Mm-hmm.
Yeah, I agree.
And I'm
I
fine
don't think we
with
need
you
another
there.
line.
He just said we needed a separate line for it.
Oh, you do?
That's why I was going by that.
Yeah, I think if you're going to add it, you're adding proof of passing all parts of the national board examination.
So you're saying a separate line?
Mm-hmm. I mean, if you want to include it, that's how I think you do it. And then if they don't provide it to you, when they say, if the scores aren't available and they provide their application, then you'd have an incomplete application, and under closed it? Under B? You have the ability to hold it until you do receive the scores, and if you don't receive them prior to the exam, then you can determine they're not qualified and they can't sit.
Yeah, because I get things piecemeal to me anyway. So I start getting transcripts, and then I get the application, and I have the fun ones that are married, and I get everything under their maiden name. And trying to match everything up, but
So while we're here, how do we feel about these 3 written references? We don't get written references. We get a little form filled out. It's just a signature
and a picture.
and a picture, which today that was like 20 years difference on the picture and the person. I guess I'm not sure, what are we accomplishing with these written references?
I was thinking they were like in statute or something, and it had to be, and they were, or maybe I'm thinking wrong. Because I was thinking the same thing at dumping those, and I was told no, couldn't do that.
I think that they have value. I think the references have value.
But they're a form.
No one ever actually writes a letter. They just,
Sometimes I do, but
Do you think 2 of them need to be by an optometrist?
that's already in here.
I know, it's on here, I'm saying.
yeah.
You need that? I mean, I don't know.
I mean, it creates at least some degree of rigor, to where one can't just,
Well,
I don't know. If it's needed.
I'm saying if they've graduated, if they've passed their boards, if they've graduated from school, what, does this benefit us approving them for licensure, yes or no, either way? We wouldn't use this as a whole block.
Well, so to get to the statute question, so one of the criteria when you're going to determine if somebody's qualified to be licensed, and I mean, I suppose that's built into sitting for the exam, but you determine whether or not they're someone of good moral character. That's built into statute. And so I would guess that's probably the genesis of it, is that you're looking at those references as establishing the good moral character requirement. But to the point, I mean, if it's just simply a form that's being filled out, and I think it does say this person is of good moral character, you don't have anything in addition to that. I suppose there's no reason why, if someone wanted to, you couldn't follow up with the references and ask questions of, the person's giving references, or develop like a questionnaire to send to them to have them complete some open-ended questions or something like that, if you really wanted to get at that good moral character criteria.
And something to be thinking about too, we're getting the new database, which will include online applications, so we can be thinking of redoing the applications, both reciprocity to include the married military spouse.
Would anyone like to make a motion about this regulation?
Adopt it
Or to
with
send it through
corrections?
the,
I'd move that we adopt it with the appropriate corrections to 65-5-2.
I think I still have a question. I'm so sorry.
Go for it.
So with the board's part 3, as long as we have received their score prior to them sitting for the exam, is that the limit on that? I just want to make sure I'm clear.
I'm sorry, I don't know what your question is.
When do we have to receive their complete application? Because you're saying you're getting pieces of it after that 30 days prior to thing.
right,
So you're requiring the application form be 30 days.
what I tell them that I absolutely need, because I at least need their name to start putting on my list for things. But most of them, 30 days out, I have about everything. A few that I might be missing, a little transcript here or there.
So I feel like I just want to make sure we're clear on like, when's the last day we're accepting a board score for them to sit? so that there's no, if we want to make sure there's no question going forward. I just want to make sure I'm clear.
10 days prior to the exam.
And then is that something we need to put in so that there's no question? Am I making sense?
Yeah, well, if that's, I mean, if that's the policy, 10 days is a cutoff, you need to put that into regulation, because otherwise it's just a non-codified policy that you can't charge someone with notice of.
Like, I just don't want to run into this again in the future where we have one student who somehow gets through and one student doesn't, and then we have upset people. Like, I want to just make sure it's consistent.
So right now it says 30 days. Okay.
Right.
You're saying shorten that to 10?
Well, I think that's what we're technically doing right now. I think.
We are.
Right.
Yeah, we are.
But only for the board scores, not for the rest of the things.
Right. So maybe like
Yeah.
like the application, can we do two different, like, do we keep the application at 30 days out and then supporting documentation can be accepted up till whatever many days or whatever? And whatever it is, I just want to make sure it's clear.
I think it is reasonable for the student to have notification whether they need to invest in traveling and hotel. So to me, 2 weeks seems,
Well, so 30 days prior to the exam, I'm sending them all emails that tell them what they still need to send me. And then I'm also telling them the date and time of the exam, the time of their interview, time Saturday morning type thing, is what I'm sending out 30 days prior. So 30 days prior, if I have everything but like MBO scores, and I'll tell them I'm still missing. And then they start telling me, oh, you should be getting them. And
Also, if the burden is on them to have a completed application 30 days out, that's also the burden telling them whether I ought to be able to make lodging.
So are we,
I realize we've let some people go beyond that 30 days, which is what I think you're getting at a little bit. But I think that as long as it's physically possible, we're allowing anybody go on beyond that past 30 days if it's physically possible. But 30 days would be a guideline that the expectation is for their application to be complete.
I mean, the way it's worded, if we add national board scores, it seems that it's saying that has to be in at least 30 days prior.
And national board
Again-
scores is part of their application. So there is the chance that if their application is not complete and they're inside that 30-day guideline, they might not be able to set for the exam. We can shorten it, but I'm saying even if we shorten it, we may still,
or maybe the application 30 days prior and supporting documentation transcripts that 15 days out. Because they're also at the mercy of the school to get me their completed or their transcripts to send them
Right.
out. And they don't send them out until the degrees are confirmed.
Does B, subsection B cover all of these? Meaning our expectation is we have notification at 30 days that you're applying, and if we don't have board scores on day 25, then we will hold your application up to 1 year. If we get it on day 26, your application's complete.
Or do we carve out a separate exception for board scores that say, the board will consider receipt of national board scores up to the date of the exam, assuming all other documentation is submitted?
Yeah, and by that time, they're sitting for the exam and not passed.
Or, up until 5 days prior, whatever it is.
right,
Yeah,
right.
because that's
Yeah.
what happened last year, is that I should have had her scores
Well, just in terms of how do we
prior
proceed,
to the exam.
just in terms of how do we proceed here, it seems as though lumping national board scores in with all the other supporting documentation might disenfranchise some to the extent that we're not comfortable doing. Is that accurate to say as the board? And so do we carve out a special exception saying the board will consider submission of national board scores up to 5 days prior to sitting for the exam, for example? I'm not saying 5 is the number. but it's separate.
Okay.
And so even
So-
if they
I guess
get
that's a
it,
Tim question.
Okay, so go back to transcripts. Don't forget MBO scores. Go back to transcripts. I could get their transcripts early, but they don't have the degree on them. So then I'm back to wanting a copy of the diploma to prove that they graduated. Otherwise, we don't know if they've even graduated school. And so
The issue at hand is not that you're receiving transcripts after that 30-day.
Well, it depends on when the exam is. When we were talking, when they were having it in June, yeah, there was times I would actually get a letter from the school saying that won't have transcripts out, but,
Is that why we moved it to July?
well, when I first started, it was in July. And then they decided that everybody graduates in May, they need to start working earlier, so they moved it to June. And it's just been in the past couple of years that it's moved back to July.
So what about this? What if we up here say, application is not complete at least 30 days prior to the examination, may not be able to set for the examination?
I mean, isn't that already
That's what I'm
said
trying
in Part B?
Right.
Like,
that's what
even
I'm
if we
trying
put
to
a 5-day limit or a 10-day limit, they still qualify under Part B.
Yeah, yeah,
And I'm truly fine if we have it the day before, take the test.
and I'm good with that.
I just don't know if, Tim, you think that's enough coverage, Part B.
Yeah, I mean, it allows if they don't have a quote-unquote complete application, you hold it until a certain point where they do make it complete. And if it's the day before the exam, I mean, I think the mechanism's there. I don't know that you need to get as specific as saying a date certain. It's in your discretion.
I just think this gives us, I mean, we have been, she's working to the last minute to try to get them included. But if they say, well, you didn't let me set for the exam, this at least gives us a reason, well, we didn't let you set for the exam because we didn't have a completed application. So this gives us a reason, if we find it necessary, to deny somebody to set for the exam.
Yeah, well, and you can also point to the qualifications regulation too.
You're not comfortable. I mean, the whole reason we're start talking about this is the exceptions we've made in the past. You're saying we can't just continue to carve out exceptions because we're waiving this requirement.
No. I mean, I'm not sure I completely follow, but but I mean, that's part of the qualifications to be able to sit. And so, I mean, if we're waiving that exception, you would be waiving a,
That was a different, yeah.
qualification by regulation. I mean, it all works together, and you have a timing conundrum, I think, that at least you all have been talking about for a couple of years now. And it's not the easiest of solutions, but I mean, I think it gives you this would give you the mechanism you need. You can hold the application even if you receive it. I think you have to receive it prior to 30 days. But if it's not complete, you have the discretion to hold it, up until a certain point.
So what's interesting is,
For the exam.
say schedule.
And I mean, that's the way you've done it, right, Jan? That would be consistent with your practice.
So you're saying we're fine leaving it like it is, basically?
Yeah.
Putting the board scores in there won't disenfranchise those people because we have the stipulation in there where we can hold the application.
Yeah, I mean, it's a little bit disjointed not to have the exam scores in the application requirement, because then they can argue, well, I have a complete application, but I still don't qualify to sit for the exam. That's a little bit, and I'm not entirely sure why it was done that way, unless there was some kind of change, in the history that I'm not aware of. But I think you shore it up by including the qualification in the application requirement, and then you can point to, I mean, like Dr. Beaver said, completed application, that's checked off, and then, you review for fully qualified. I mean, it seems to make it more consistent with what current practice is.
Can we see the change you made again? Okay.
I move to do it. Is that still on the floor, or you want me to restate my motion? We good? Okay, so I move that we approve 65-5-2 with the discussed corrections.
Second. All in favor, say aye.
Aye.
Opposed, same sign. And motion passes. All right. Tim, I was unaware if you had anything that we need to meet in executive session about.
I just kind of threw that on there just to make sure.
Yeah, no, I don't think so unless any member has something they'd like to address.
All right, I think that wraps it up. Our next meeting is July 12th and 13th.
And I'll send out a doodle poll for the week of May
May.
13th for the, talk about the exam.
And then, Jan, let's try to put on the agenda the regulations that we missed.
And I think we'll also be having a hearing that day too. I just remembered. I sent it to you and Tim.
Yes, I had some questions about that one too.
Yeah.
Regulations on the remote meeting, we'll have regulations, discuss regulations at that remote meeting?
No.
Or at the, in person?
No, because it won't be 30 days out, or 60 days out. Because yeah.
All right, any other questions or concerns?
Can I get a clarification on something? So the FBI stuff, so I've done mine as a new member, but it made it look like I got to do it again because it's my yearly, but I just did it. So how do I fall?
So what there's two different things. There's the criminal justice thing, which is the FBI one, which is like 30 minutes. And that you have to do that yearly, and that's based on.
So I've already done it.
You already done that. And then there's another one from OITS that is security-based training thing that has all these different parts to it. You have until December 31st to get that one done. And that's another annual thing that's really similar to the KBI thing.
So I think I've done both.
I don't think so.
I have not? Okay.
You've done one.
Okay.
Yeah.
Okay. So
And-
I'm going to get your help on which one I haven't done.
Yeah.
Okay.
And I think you're due to get your FBI one done.
I'm a little behind.
Because I can run a report.
Meeting is adjourned. Or do I need to make a motion? I'll make a motion to adjourn the meeting. Do I have a second?
Second?
All in favor, say aye. Opposed, same sign. And meeting is adjourned.